One first appeal arising out of land acquisition case.
कब करना?
Next week, any day.
It is कौन सा वाला है?
कब है?
कहाँ का एक्विजिशन है?
बोकारो. ये 5 तारीख को 5th May 2025 award has been passed against the appellant, though the appellant has got the right title in terms of possession of the land.
It has not been admitted so far.
No. It fresh
file. कल tomorrow.
इसमें some defects are there.
कोई ना.
Yes.
Not rejected.
Make kindly.
Nothing.
Next week.
आपका ये सब कहानी हम नहीं सुनेंगे. बिना डिफेक्टिव मूव किए मेंशन करते हैं. आराम से करते हैं.
Urgency is there.
There is no urgency. You have not removed the defect.
Since the record has not yet been provided.
Item 3, second appeal 274 of 2017.
Second appeal number 274 of 2017. Also for the parties are present. The counsel for the appellant has filed proposed additional substantial question of law during the course of hearing.
Yes.
How many proposed additional substantial question of law have you framed?
3 or 4 only.
5.
But
ज़्यादा substantial question of law frame कराने से लगता है कि कोई merit नहीं है बस. कोई merit है ही नहीं, बताइए.
बता. इसमें main जो की substantial question of law हमने frame किया है, that is with respect to the agreement.
Sorry?
Agreement. The plaintiff has a case that way back in 30th January 1990.
इनका वो mic on करें.
30th of January 1994, plaintiff along with one Asad entered into an agreement.
What is the date?
Date is 30th of January 1994.
31/1994. Agreement.
That is Exhibit 4.
Exhibit 4.
Yes.
Plaintiff with
Plaintiff and one Asad.
she is a defendant.
No, she is not a party in the suit. Then, the total consideration amount which was agreed was 75,000, and out of that 35,000 was paid to the defendant.
Paid when?
Paid on the 31st of January itself, and subsequently, by two transactions. That is on 4th of January. 4th of March 1994 and 11th 12/1994. Further, by way of two transactions, 15,000 and 5,000 rupees were paid through the husband of the plaintiff, Dharmender Vishwar.
So how much is remaining?
The remaining was only 20,000. Because altogether it is 55,000. Only 20,000.
Is there any finding that the remaining amount was 20,000? Is there any finding of fact by the learned courts that the remaining amount was 20,000?
Yes, that is there. But there are some more facts which I am required to say. What happened at the second lessee, Asad, she later
She is
on,
a lessee or she is just agreement holder?
agreement. But then second one, she changed her mind, and another person who is the plaintiff number 2, she was substituted in her place.
Plaintiff number 2 was substituted by
Substituted.
another agreement.
No, there was no agreement. There was only oral agreement.
By oral agreement.
By oral agreement. And
Is there any finding to that effect?
yes, the finding I am coming there. Then, my lord,
So the written agreement is substituted by an oral agreement.
with respect to plaintiff number 2.
It's one and the same thing. It's a new agreement altogether.
Yes.
You see, just tell us one thing. A new person enters into picture. Still the old agreement would survive.
My lord, so far as the plaintiff number 1 is concerned, it will survive.
What do you mean plaintiff number 1?
There are
The
two
agreement was a joint agreement.
Yes, it was a joint.
Two parties. Then how the agreement does not survive anymore?
No, your lordship may kindly appreciate. There are 2 persons. They all together seven katha and 7 katha.
And moreover, you did not make Asha Devi as party.
Asha Devi instead of Asha Devi. Actually,
Instead, substitution हुआ है क्या? Asha Devi has expired.
no, I am coming to that. My lord, there was a permission. That permission under my lord, the Urban Sealing Act was in the name of the plaintiff number 2. She took permission. So, my lord, so far as the agreement your lordship is concerned, with respect to plaintiff, and my lord, even my lord, an oral agreement with respect to my lord, plaintiff number 2 is corroborated by the permission.
नहीं चलेगा आपको इस second appeal में.
Apart from your lordship may kindly appreciate.
And you did not make Asha Devi as party.
No, Asha Devi is not a party. You are not required also. Not required also. Because, my lord, the pleading to that effect was there. And, my lord, evidence to that effect has also been there. My lord, so far as
Who
the...
can say best that she is not interested? Merely because permission has been given in name of one or the other person. Does the agreement stand substituted?
My lord, may kindly appreciate, there are other facts also. My lord, the defendant did not appear to deny that.
Who?
There is no evidence at all.
How will defendant deny the status of
Yes,
Asha Devi?
she is the best person to say.
She is
whether
the best
this-
person
she
to say
entered into
she is not a
agreement or
party.
not.
She is not a party.
No, defendant is a party.
No.
Defendant.
Asha Devi, her status did not come,
No,
did
no,
not
that
depose
may
before the
be-
court. It's not a party before the
The
court.
person who entered into an agreement with Asha Devi and the plaintiff number 1, there is merely a pleading on their behalf that in the form of a written statement. No witnesses has been examined. My lord, she even did not appear, your lordship, to deny that as such there is no agreement. And my lord, she did not even deny the payments also. Thereafter, my lord, the learned trial court said that it is not a concluded contract. So far as the plaintiff number 1, your lordship, it was a concluded contract. Permission was also sought.
Plaintiff number 1, it was a concluded contract for plaintiff number 1 and Asha Devi. You cannot
No,
sever it like
No,
this.
we can sever it. It is sort of a joint agreement.
Mr. Sharma, आपको नहीं लग रहा आप थोड़ा out of the way ही बहस कर रहे हैं?
हम इसको हम दिखाएंगे. इसको हम दिखाएंगे.
ऐसा severance नहीं होता है agreement का.
नहीं, ऐसा severance हो सकता है, पर सेक्शन 12 देखा जाए.
Provided she is also
देखा
part.
जाए. सेक्शन 45 देखा जाए. Of the contract act देखा जाए. There is no bar in it. There is no bar in the law that no two persons can join an agreement. Rather, my lord, 2 promises can be there, 2 promisee can be there, and there to that effect, my lord will find there are several provisions in the contract act, and so far as the specific performance of contract your lordship is concerned, my lord will find that provision in section 12 of the specific. And apart from that, your lordship may kindly appreciate, appellate court, your lordship, has considered these aspects and has directed the defendant to return 39,000 to us. So far as the plaintiff number 1, your lordship is concerned, plaintiff number 1 agreement has been accepted, and my lord, payments has also been accepted, and my lord, it has been directed to return. And so far as my lord, this agreement is concerned, we brought on record evidence of my lord the scribe.
Mr. Sharma, आप अपनी बात से मुकर नहीं सकते. पिछली बार आपने बोला था खाली रिफंड पर आप सब्सटेंशियल क्वेश्चन, तो 5 आप
तो हम
सब्सटेंशियल
पहला ही
क्वेश्चन,
नंबर हमारा बना दिया गया, पहला ही तो मैं
दिस इज नॉट बीइंग फेयर। नो,
मतलब
आप फाइल पढ़ के बोलो।
हम पहला पूरा फाइल पढ़ के ही हम बनाए हैं। अब पहला जो है
इसको आप फर्स्ट अपील में मत कन्वर्ट करो।
नहीं, फर्स्ट अपील में नहीं लगा, फर्स्ट देखा जाए whether the learned appellate court while passing into judgment and decree committed perversity in holding that there is no concluded and valid agreement between the plaintiff and plaintiff number one and the other. Malad, here your lordship, the appeal which has been filed, your lordship, is at the instance of Malad, the plaintiff number one itself. Plaintiff number two, your lordship, is a performer respondent in the present. She has not Malad, approached Malad, and rather perhaps after service of notice also she is not
Plaintiff number 2 is not interested.
not interested.
Right. So therefore, once the plaintiff number 2 has accepted the judgment and is not interested, then how the court will enforce a sale? How the court will enforce a sale?
That will also that we will also argue.
Excluding plaintiff number 2.
But not order 41 rule 4, your lordship may kindly see. There is no bar, my lord, that all the plaintiffs should be here. Your lordship may kindly see order 41 rule 4.
Even for specific relief act?
Even for any declaration.
It is not a declaration. You are seeking specific
Yeah,
performance
for
of
even
contract.
for a specific
The party is not interested.
My lord, so far as your lordship may kindly appreciate, the agreement has two parts. And there are two, my lord, I will show from the recital itself, my lord, that the plaintiff number one has entered into an agreement with respect to 5 katha, 3.5 chatak. So far as the plaintiff number 2, your lordship, she is only interested, my lord, with respect to 2 chatak. And not only that, after my lord, entering into my lord, agreement, my lord, we came in possession, we constructed a house, we residing there, and not only that, your lordship, the defendant, your lordship, instituted a suit for eviction of my lord husband, your Dharmender Viskarma. That was dismissed, and all the pleadings, both the case, the pleadings are similar. Against that, there is no appeal also. So, my lord, so in a part performance of contract, your lordship may kindly appreciate, the possession was delivered to us, and we have, my lord, constructed the house, and I am still residing there with my family members. My lord, the agreement has been proved in accordance with law. The scribe has been examined. They have not even cross-examined him.
May not have.
All evidences has been admitted, your lordship.
May not have. May not have process.
My lord, how an agreement is to be proved? My lord, may kindly appreciate a person who is a party to the my lord, the agreement has been examined. My lord, the scribe who has written the document has been examined, and my lord, in accordance with law, this agreement has been proved. The signatures has got been marked, which are exhibits, your lordship.
No, the agreement has been proved, but one of the party is not interested in executing the agreement.
So far as
For specific performance of contract.
My lord,
Then under such circumstances, a fresh agreement should have been entered into.
my lord, may kindly appreciate. So far as the plaintiff number 2, your lordship, is concerned, she joined hand with this plaintiff, and she filed an application. Filed a suit.
Mr. Sharma, a third party entering into already a written agreement without any further written document.
My lord, your lordship.
Orally, one person will enter into, and you want us to take it.
My lord, may kindly appreciate.
Yes.
There is no bar in the law that a specific performance cannot be given for an oral sale. There are two judgments to that
It
effect.
is not a matter of oral sale. Then you are talking about a new agreement altogether.
My lord, may kindly.
There are two things. Either you stick to the old agreement or you stick to the
So
new
far as the
agreement.
plaintiff number 1, your lordship.
Which is, do you want to stick to the oral agreement?
No, I am not. I am
You
not
want to
arguing.
stick to the written
My
agreement,
lord, I am not arguing.
substituted orally by a new person.
My lord, let me
Yes, sir.
I am not arguing on behalf of the plaintiff number 2, your lordship. My appeal, your lordship, before us, before my lord, is at the instance of plaintiff number 1 only. My lord, may kindly have a look on the agreement itself.
It is also there in the first appellate court judgment, page number.
Your Lordship may kindly see agreement itself. It is the certified copy. My lord, in the cost title itself, your Lordship will find there is a description of 3 and 5 and 5 kattha and half, and my lord, 2 kathas only. In the house title itself, your Lordship may kindly see. It is bifurcated itself. It is bifurcated itself, your Lordship. And my lord, the direction which the learned appellate court has, your Lordship, has given to my lord the defendant with respect to the plaintiff number 1 only. Asha Devi has contributed 16,000. To that there is no direction also. I am not contending to that. But so far as my agreement, your
So
Lordship,
therefore,
well,
Asha Devi had contributed how much?
she contributed 16,000.
16.
And plaintiff, there is a pleading to
Just
that
a
effect. There is a pleading to that effect that was returned by the plaintiff number. So
Who can certify that it has been returned?
the best person to certify was
The only person to
No.
certify.
the best person was to certify was the defendant itself, and she has not
Who
deposed.
has returned it?
Madam,
Who has returned that money to Asha
that
Devi?
plaintiff number 2 in presence of the defendant itself, and that is certified, that is corroborated, and because my lord, there is a permission in the name of plaintiff number 2. Had there been no such fact,
कुछ नहीं है आपके केस में।
नहीं, हमारा केस तो क्लियर है,
कोई
हमारा
validity नहीं
एग्रीमेंट भी
आपके
क्लियर
केस
है,
में।
हमारा तहजूर एग्रीमेंट भी क्लियर है, हम पोजीशन
रहा
में भी हैं, हम रह भी रहे हैं, हमको हटाने के
ऐसे एग्रीमेंट में ना एक लाइन हटाकर नहीं पढ़ सकते हम। फ्रेश एग्रीमेंट कर
नहीं तो
लेते हैं।
हम
Who
इसे-
stopped you from make? You just tell us. You want to stick to the oral agreement or you want to stick
I
to the
want
written
to
agreement?
stick both.
Both.
Yeah. So
है
far
ना,
as
दो नाव में पैर रखेंगे।
so far as
Right.
plaintiff number
अपने
1
कन्वीनियंस के हिसाब
नहीं,
से।
हम plaintiff number 1 का
फिर?
जो केस है उसके लिहाज से there is an oral, there is a written agreement, there is no oral agreement. So far as the plaintiff number 2, your Lordship, is concerned, she is contending that there was an oral agreement with respect to her portion of land, and that has been disbelieved. Let it so. So far as the plaintiff is concerned, the payment has been given, everything has been given. There is a direction to defendant to return back. So what more is required? And not only that, there is a
अगर इस
permission in
केस
my
में
name
आपकी इस
also.
बात को मान जाएंगे ना तो हम आज कुछ नया ही चीज सीखेंगे।
नहीं तो नया
Which
ही-
I have never learned.
there is-
I am open to learning. There is no bar. Judges can always keep learning.
Not a new one. Such agreement, there is no bar. Your Lordship, may kindly see section 12 of the Specific Relief Act, your Lordship. May kindly have a look on it, section 12 of the Specific Relief Act.
That written agreement can be substituted by an oral agreement.
No. I am with respect to part performance of the agreement, contract. If there is two parts. There is no bar in the law that cannot be specifically performed.
Yes, it can be
Yeah,
performed.
then-
Two
then-
part matlab kya? You see, the point is that there is an agreement of sale between A and B on the one hand and Mr. C on the other, right? Now you want, and the sale deed should be executed between A and C. How is it possible?
No, I am not on that.
This is what you are
No, I am
wanting,
not on
between A, D and C.
No,
How is it possible?
What I am asking you, that is what is my agreement, that the sale should be executed with respect to 7, 3 and 5 and 5 kattha and 3.5 kattha, which is in the agreement itself, in my favor. So far as the rest portion is concerned, I am not concerned.
This portion means
2 kattha.
this agreement is in two parts.
From cross title itself, your Lordship, may kindly see.
Okay. If this agreement is in two parts, does the agreement say that 2 kattha will be for party number 1 and 1 kattha will be for party number 2?
That is from the very agreement. That is very apparent from the agreement itself. if the two persons, your lordship.
2 persons means what?
Two persons, one is my lord, the plaintiff number 1,
Yes.
and another, your lordship, is one Asha Devi.
Yes.
If, so far as my
Does it say, this agreement, does it say that with respect to Asha Devi it is 1 kattha or 2 kattha?
Yes.
And with respect to the plaintiff
yes,
number 1?
कॉन्स्ट्रक्शन में देखा जाए तो 5 कट्ठा 3 छटाक लिखा हुआ है ऊपर, और उसमें 2 कट्ठा लिया हुआ, टोटल लैंड इज 7 कट्ठा 3 छटाक, तो कैटेगराइज है, वो तो बाइफर्केटेड है। इसमें ये भी लिखा हुआ है कि लेखकारी के नाम से हम परमिशन लेके सेलिट करें, तो लेखकारी में तो हम आ ही गए।
और आपका ये 5 कट्ठा 3.5 छठा का बाउंड्री कहाँ है?
Boundary तो as such bifurcated, but that can be identified. There are judgments to that effect also. Kerala case का judgment हम दिखाएंगे।
कहाँ से आइडेंटिफाई, कहाँ से बाइफर्केशन है?
इसी एग्रीमेंट से ही बाइफर्केट होगा।
कैसे
हमारा 5 कट्ठा अगर कोई लैंड है,
हाँ।
कोई लैंड है, अगर कोई टोटल लैंड का मान लीजिए बाउंड्री दिया और अगर
उसमें से 5 कट्ठा
उसमें 5 कट्ठा 3 छटा है, तो कम से कम 3 बाउंड्री तो एक रहेगा।
कैसे?
आखिर एक ही तो लैंड तो एक ही है ना
भाई, एक लैंड है, उसमें से किस चौहद्दी का कौन सा पोर्शन बाइफर्केटेड है, किसका क्या है, ये कैसे होगा?
लार्जर पोर्शन तो 5 कट्ठा हाफ है।
लार्जर पोर्शन इस तरह से नहीं होता है। हाउ विल द
नहीं,
कोर्ट
इस पर
एक्जीक्यूट?
भी
कोर्ट विल नॉट बी एबल टू एक्जीक्यूट द सेल डीड आल्सो।
The sale deed will be established.
How will it be
अब हम इसको
executed?
दिखाएंगे।
कोई बाइफर्केशन नहीं
सेल
है।
डीड का एक्सक्यूशन का कोई इसमें प्रॉब्लम नहीं होगा। आइडेंटिफिकेशन के लैंड के समय प्रॉब्लम हो सकता है। और
आइडेंटिफिकेशन सेल डीड कैसे एग्जीक्यूट?
माय लॉर्ड मैं काइंडली अप्रिशिएट, हम पोजीशन में हैं, हम अपना जब मकान बना लिए हैं, उसमें मकान बना के उड़ रहा है। हमारा अगर आज के तारीख में अगर ये अगर मेरा अगर एग्रीमेंट भी वैलिड है, तो भी आई कैन हैव एब्सोल्यूट राइट। आप वो इविक्शन सूट भी हार चुके हैं हमारे खिलाफ, तो
बहुत
हमारा
अच्छी बात है, इविक्शन सूट आप एंजॉय करिए बिना सेल
नहीं,
डीड
तो
के, क्या
हमारा
दिक्कत है?
सर्किट नहीं है, दूसरे को बेच भी देंगे और बेच रहे हैं दूसरे। हमारा इस प्रॉपर्टी को आज बेच देंगे, ये आप बेच रहे हैं, तो उस कंडीशन में आई विल बी नो, मेरा तो एग्रीमेंट वैलिड है। और अगर मेरा एग्रीमेंट वैलिड नहीं होता तो किस बात के लिए हमको 39,000 रुपया देने के लिए कहा है? पैसा तो इन्होंने लिया, और उतना ही नहीं है, मेरे से 19,000 रुपया फर्स्ट टाइम लिए, उसके बाद हमको ये क्या नाम है 15,000 लिए, फिर 5,000 लिए, तो मेरे पार्ट के लिए ना पैसा ले रहे थे। तो हमारा सो फार एज माय एग्रीमेंट इज कंसर्न्ड, इट इज वैलिड। अब रह गया जैसे
सेवरेबल नहीं है ये
जी जी
ये एग्रीमेंट सेवरेबल नहीं है।
नहीं, सेल एग्रीमेंट तो हुजूर सेवरेबल है, ये है। और हमारा और रह गया प्लेंटिफ नंबर 2, अगर प्लेंटिफ नंबर 2 अगर नहीं आती, अगर नहीं ज्वाइन है,
आपने आशा देवी को पार्टी क्यों नहीं बनाया?
आशा
डू
देवी,
यू हैव एनी एक्सप्लेनेशन फॉर दिस?
my lord, आशा देवी is not a necessary party so far as I am concerned.
She
can
would have certified उनका कितना पेमेंट है, आपका कितना पेमेंट है,
lord,
उनका
मैं-
कितना
मैं-
एरिया
the
है।
best
She would have
person-
said that she has no objection, she is not interested in rest of the
No, she
property.
is interested. She has deposed, my lord. She has appeared and she has deposed what the fact which we are saying.
She is a witness on whose behalf?
She is witness on her behalf itself, and she
She is
and
not
they
a
have-
party, no.
Yes,
Asha Devi is not a party.
Asha Devi not.
She has deposed.
No, not Asha Devi.
I am talking about only Asha Devi.
My lord, may kindly understand the person who takes money. He is the best person to say whether he has taken money from whom or not. And it is, my lord, it is on record.
Just tell us, is there any law that money consideration can flow from anywhere? A third party can also give the consideration with respect to your property. Is there any legal bar?
My lord, yes.
There can be two parties contracting for an agreement of sale, but the consideration is coming from somewhere else.
My lord, who will deny it?
So therefore,
A
Asha
person,
Devi,
you have taken money from whom? If there is a specific pleading from the plaintiff.
is there any finding that Asha Devi was a necessary party?
No, there is no
There
finding.
is a finding, my lord, that because of non-joinder of Asha Devi, this agreement cannot be executed and it is not a concluded agreement.
This
So-
is the question of law.
My lord,
उसके बिना तो आपका कोई question of
And
law
moreover,
decide ही
Lordship, in
नहीं
the
हो सकता.
agreement, Lordship,
Whether
it is-
she is a necessary party.
The amount
my
of
lord,
consideration has
she
also not
is
been
not a
bifurcated.
necessary party. In view of the fact, my lord, that my lord, there is no specific, no suit for a specific performance on her behalf. And my lord, in place of her, the my lord, plaintiff number 2 has approached and filed a suit, and for her name the permission was taken by the defendant. It itself, my lord, suggests that the what is the contention of the plaintiff is correct.
करिएगा आपका भी ये बताइए.
तो हम एक वही वाला फ्रेम करने में
अब तो मंडे बोल रहे थे ना, मंडे को सुनेंगे.
मैंने हम कर
The agreement for sale also, Lordship, the amount of consideration has not been bifurcated. Also, Lordship, the intention of the parties that
We'll hear you.
it is not,
ये इसको
not a-
डिसाइड ही कर देते हैं.
it is not a
ये
severable
सब
agreement.
कहानी जो है ना कि जिसको मन होगा वो आके स्पेसिफिक परफॉर्मेंस फाइल करेगा. जो पार्टी है एग्रीमेंट का, सबको पार्टी भी नहीं बनाएंगे, फिर भी स्पेसिफिक परफॉर्मेंस होगा. ये तो समझना होगा हम लोग को भाई. मतलब we have to lay down some law on this.
सेक्शन 12 देखा जाए.
हम सेक्शन देखकर ही डिसाइड करेंगे, बिना देख के थोड़ी डिसाइड करेंगे.
रिलीफ फैक्ट का ऐसा पावर
सेक्शन देखकर ही डिसाइड करेंगे मिस्टर शर्मा. और आपसे बेहतर कौन सेक्शन हमको पढ़ा सकते हैं ये बताइए. इसीलिए उसकी आप चिंता ही मत
हम लोग
करो.
तो रोज सीखे.
हम लोग तो रोज ही सीख रहे हैं.
सर,
Everybody is in a learning mode.
we are learning it. The Lordship has given patient hearing to us. We are very much obliged for it. Such case requires patience. But this fact is important. Well, because if the second question of law, even if it is answered in my favor, if the agreement, your Lordship, is not a valid agreement, then there no specific, no court can direct for a specific performance. And I am on a specific point. If they have accepted payment, so far as I am concerned, now it can be a question of law. That can also be framed whether such bifurcated agreement can be is put to the for that. Your Lordship will-
We can frame A and C, and additionally as to whether Asha Devi was a necessary party in the case. उसको हम इग्नोर नहीं कर सकते.
ठीक.
A and C. Yes, counsel. ठीक है. देखिए ऐसे नंबर 274 of 2017 फर्दर आप सॉरी ई क्या है?
ये हमारा स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट के बाद पोजीशन
नहीं नहीं ये सब नहीं. सब्सटैंशियल क्वेश्चन ऑफ लॉ को उसी तक रहने दीजिए. Heard the learned counsels on the additional substantial question of law. It has been submitted that a copy of the agreement involved in the present case dated 31/1994 with the bracket Exhibit B,
Exhibit 4.
Exhibit 4 has been placed, in which is an agreement between Premlata Pandey on one hand and Srimati Meena Devi and Srimati Asa Devi on the other hand. Admittedly, Srimati Asa Devi was not made party in the suit. Counsel for the appellant has submitted that even in absence of Asha Devi, the agreement with respect to the plaintiff, namely Meena Devi, was severable, and therefore specific performance of contract, therefore the suit was maintainable, and the learned courts have,
Agreement with respect to plaintiff number 1 is valid.
and therefore agreement with respect to plaintiff number 1 was valid in all respect. The learned counsel has referred to the additional substantial question of law filed during the course of the hearing. Counsel for the respondent has opposed the prayer and has submitted that Asha Devi was certainly a necessary party. The agreement was not severable. It was not clear as to who had paid the consideration amount. The boundary of the property with respect to Meena Devi and Asha Devi was also not bifurcated.
And also the amount of consideration also was not bifurcated.
And the amount of consideration was also not bifurcated. And therefore, the suit has been rightly dismissed. Considering all the aspects of the matter. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the following additional substantial question of law is also required to be considered. A लिखिएगा, A, C, ठीक है, आप C देख लिए, A and C, and whether Asha Devi was a necessary party to the suit. और एक और बनाइए, whether the agreement was severable in nature. Correct. Severability का तो point बनेगा ना, इसमें आप बनाए हैं क्या?
लेकिन हम अपना ही पहला वाला जो है I'm asking only with respect to my, because what has also directed them to pay consideration amount with respect to my.
Whether the
सेपरेट मीटिंग वाला है, ये वही है।
severable होना बनेगा ना एक substantial question.
उसको बना सकते हैं, लेकिन अब ये जो हमने बनाया है वो विथ रिस्पेक्ट टू मी, क्योंकि डायरेक्शन हमने इसमें लिखा है कि हम इनको डायरेक्शन विथ रिस्पेक्ट टू माई सेल्फ ही, सेपरेट तो खुद कोर्ट ही करती है।
Because Lordship, the Asha Devi did not oppose the court.
No.
Direction was made.
That's right, just a minute. ये whether the agreement was severable in nature
Lordship.
can be a substantial question of law.
Because their case is based on the fact that
It is severable.
their part of the agreement can be executed.
That's
so
right.
it has to be severable.
Whether the agreement was severable in nature.
And can be put to specific performance.
Severable होगा तभी तो put to spell. Otherwise कैसे ही होगा? Whether the agreement is severable in nature and would be subject matter of specific performance of contract only with respect to Srimati Meena Devi, the plaintiff number 1, in exclusion of Asha Devi. Correct? कब करेंगे बताइए?
Next Monday.
Post this case on next Thursday. नोट्स बनाइए क्या क्या पढ़ेंगे
Lords, there were personal notes got some judgments with regard to the specific performance of contract, section 16C, readiness and willingness.
चिट्ठी ऑन कॉन्ट्रैक्ट उठाइए उसी में आपको सब मिलेगा है कि नहीं है कि नहीं
Lords, I will find out.
योर सीनियर मस्ट बी हैविंग
बट एक दिन हमने कहा था एग्रीमेंट में अगर मंडे का साइन नहीं हुआ मंडे का साइन नहीं भी हो तो उससे कोई फर्क नहीं पड़ता है सुप्रीम कोर्ट जजमेंट ऑन दिस Para 7. All agreements of sale are bilateral contracts and promises are made by both. The vendor agreeing to sell and the purchaser agreeing to purchase. It cannot be said that unless the agreement is signed by both the vendor and vendor, it is not agreed. Even an oral agreement to sell is valid. If so, a written agreement signed by one of the parties, if it evidences such an oral agreement will also be valid. Moreover, in India, an agreement of sale signed by a vendor alone and delivered to purchaser and accepted by the purchaser has always been considered to be a valid. In the event of breach of the vendor, it can be especially enforced by the purchaser. There is, however, no practice of purchaser alone signing an agreement of sale.
इसी में लगेगा ये
इन्होंने ये रेस किया था
चलिए इसमें बताइए फाइल में
It is well settled.
parties to prepare short synopsis of argument with respect to each and every substantial
Item 4, second AP 146 of 2022.
इसमें जब आप बनाएंगे ना तो अनडिस्प्यूटेड फैक्ट्स को एक जगह कर है ना यस
Entered my appearance.
टाइम नहीं देंगे टाइम मत मांगो
So only my request is that Millets, I would not prepare to that extent because there is only one substantial question of law.
एक ही बात है एक ही बात है जजमेंट इज कॉपी पेस्ट
Millets,
साथ साथ पढ़ते हैं इसमें क्या
I
करना
have gone through it. Millets, I have got one judgment, recent judgment of our Supreme Court. I will.
कॉपी पेस्ट है ना जजमेंट आप देखे हैं कि नहीं
Millets,
देखे
I have gone through it.
इट इज कॉपी पेस्ट
There's only one point which is to be, which can be argued.
बताइए
This is the latest judgment of our Supreme Court. It's because I don't have the civil memo of appeal with me. So Honorable Supreme Court Lord has laid down that the determination of question of order 41, rule 31 minutes, rule 30 and 31 both is to be read along with minutes. Plus, if I may be permitted to read from paragraph 5 onwards. Paragraph 5 onwards of the judgment. Many minutes. Many minutes. Paragraph 5. It
Para
appears.
number?
Sorry, minutes.
पैरा नंबर
Para 5 onwards. Minutes. It appears that the High Court, relying upon few decisions, took the view that Order 41 Rule 31 of CPC is mandatory, and the failure on the part of the appellate court to frame the points for determination as per the provisions of Order 41 Rule 31 CPC would vitiate the entire judgment and make it wholly void. Having heard the learned counsel appearing for the parties and having gone through the materials on record, we are in complete disagreement with the view taken by the High Court. We propose to follow the dictum as laid down by this court in the case of such and such reported in 2006 3 SAC 224, wherein this court observed that whether in a particular case there has been substantial compliance with the provisions of Order 41 Rule 31 CPC should be determined on the nature of the judgment delivered in each case. Non-compliance with the provisions by itself may not vitiate the judgment and make it wholly void, and may be ignored if there has been a substantial compliance with it.
What
We
is
may-
the meaning of a substantial compliance?
That's if we go through the
Is
provisions of
the first appellate court supposed to examine all the fact and law and apply independent mind to it. Is it open to the first appellate court to pass a copy-paste judgment?
No.
This is what has been done. Therefore, there is no compliance.
But that's-
The question of law has been framed not because there is no specific point of determination. The appellate court has taken up all the issues, so there is a point of determination.
and appellate court has discussed also.
This discussion is copy paste. This I will demonstrate before you if you have not understood.
But I have gone through.
है ना, कॉपी पेस्ट है कि नहीं है?
I have gone
फिर बड़ा अच्छा है. कॉन्करेंट फाइंडिंग पढ़िए आपको देखना है. It is an eye opener for us that this can also happen in Jharkhand. In the same form, in the same manner, judgment is copy paste.
It has been written in a manner the trial court has written it.
Not only in the manner, in the same language.
No determination of the question which they have raised in civil appeal has
In
been
fact,
considered.
whatever arguments they have raised,
I agree.
there is no consideration to that.
I agree to it.
It is absolute copy paste. So you don't need to take time on this. We will simply
No, because
remand it.
I'm not taking time. I was only praying that if I would be able to assist your lordship on this point, that because I have gone through the brief yesterday and I have tried to find out this judgment, which is latest judgment.
No, I appreciate this. You see, in a case where there is a concurrent finding, we have to primarily see
No,
as to
because
whether
I totally agree with your lordship's Millard. So when I have gone through yesterday the brief, I have also got my mind that yes, it is.
it is copy paste. It is astonishing and shocking. In one judgment, I have seen Hindi में judgment है trial court का translate करके English में. और आप यकीन नहीं करेंगे जब आप वहाँ पे वो translation में जाते हैं, मैंने किसी को बोला था कुछ portion translation में देखने के लिए somebody else, not in my office, कि भाई इसका translation.
Outside court, I am just saying. Yesterday, in one of the criminal raid, I had made a prayer. I had prayed for custody of a child. Order was in the favor of father. It was lastly handed over to the father. So the order was there. In vacation, my client called me and asked me for that order, which was passed by this honorable. I soft copy I had sent it because certified copy was not available. What he did, he translated that order, which was in English and Hindi, and the word execution, which was written that police went for execution of the custody of the child, mother went away, mother fled away. So what he did, he has translated that order sheet in Hindi, and then he sent me that execution was translated into Farsi. So he said, he was shocked, and he just called me out and said, "Ki, sir, इसमें तो फांसी का कुछ
फांसी की सजा हो गई है. Let us see which all paragraphs are copy paste, right? क्योंकि that will be the ground for remedying them.
I have given the chart in this.
You have given the chart also.
Yes. At page 4, my lord, of the memo of appeal.
कुछ तो आपने छोड़ ही दिया है. 32 वो भी कॉपी पेस्ट. देखिए आप अपने एपेलेट कोड का पैरा नंबर 30 से लेके, राइट?
Milan.
मिलाते हैं इसको जो आप छोड़ दिए. 30 is equivalent to 26.
26 page 87.
नहीं, 30 is equivalent to
But the page, para 30 of appellate court's judgment is equivalent to para 26 of the trial court.
para 26. है same?
Yes.
Copy paste?
Yes.
31.
Milan.
31 उसके बाद इन्होंने कुछ प्रोविजन ऑफ लॉ कोट कर दिया है बीच में.
31 exactly is not.
31 is there.
Yes, it
I'll
is
show
there,
it.
but it is not in the trial court's judgment. 31.
It is there. I'll show it to you. हम बड़े ध्यान से इसको देख रहे थे. It is there. Para number 30. Trial court का para 30 is same as appellate court's para 31.
Yes. Yes.
Correct?
Milan.
Appellate court का para 30 is same as trial court का para. Sorry.
26.
Just a moment. इसको रुक जाइए, हमको लिखने दीजिए. Trial court and appellate court, right? Appellate court का para 31.
नहीं 30.
देख एक सेकंड, 31 पहले नोट करते हैं. Is same as trial court का para 30. Correct?
Yes.
उसके बाद appellate court का ट्रायल कोर्ट का पैरा 30 हो गया.
वो तो हो गया.
हाँ.
Para 30 of the appellate court's
Appellate
judgment
court
is
का
equivalent to
30.
para 26.
26.
पैरा
of the trial
30 is
court.
equivalent to पैरा 26.
Minus.
करेक्ट.
Yes.
उसके बाद आइए नेक्स्ट में. उसके बाद 32(1).
32(1) is 31(1).
32(1) is 31(1), राइट? ट्रायल कोर्ट का 31(1), 31(2) is appellate court का 32(1) and
32(2).
32(2), राइट?
Milan.
हो गया. अब पैरा 32 भी मिलता है. ट्रायल कोर्ट का पैरा 32 इज सेम एज
33.
पैरा नंबर 33.
33.
एपिलेट कोर्ट का पैरा 33 इज सेम एज ट्रायल कोर्ट का
32.
पैरा 32. करेक्ट?
Yes.
ये तो हो गया 30 से कहानी फाइंडिंग्स का. ठीक है, उसके अलावा आप देखिए ट्रायल एपिलेट कोर्ट का पैरा 28. is same as trial court का पैरा 25. है ना?
Trial court's para Milan.
पैरा एपिलेट कोर्ट का पैरा 28 is same as trial court
25.
पैरा 25. एपिलेट कोर्ट का पैरा 27 is same as trial court पैरा 24.
Milan.
ट्रायल कोर्ट का पैरा 26 is same as एपिलेट कोर्ट का पैरा 30. उसके बाद ट्रायल कोर्ट का पैरा 22 is same as एपिलेट कोर्ट का पैरा 25. नहीं सॉरी,
Para 11.
just a moment. appellate कोर्ट का पैरा 25 is same as ट्रायल कोर्ट का पैरा 22. Kindly check.
Yes, yes.
ट्रायल कोर्ट का पैरा 23 is same as appellate कोर्ट का पैरा 26. Correct?
Yes.
ट्रायल कोर्ट का पैरा 21 is same as appellate कोर्ट का पैरा 23. Check please.
Yes, ma'am.
Right? Appellate कोर्ट का पैरा 21 ये इंटरनल पेज 38 में आइएगा. 21 रोमन 1 21 रोमन 1 2 21 रोमन 3 is same as ट्रायल कोर्ट का नहीं, ये खाली एग्जिबिट का डिस्कशन है, ये फाइंडिंग नहीं. इसमें भी कुछ कॉपी पेस्ट है. प्रॉमिसरी नोट ये एपलेट कोर्ट का ऐसे कुछ बीच बीच में हम लिखे हुए थे. ट्रायल कोर्ट का पैरा 15 इज इक्विवेलेंट टू एपलेट कोर्ट का पैरा 14. चेक करिए प्लीज. ये तो कोटेशन हुआ. उसके बाद 14.1
14.1 is equivalent to 16.1.
14.1 is equivalent to 16.1 of trial court.
14.1 of the appellate court's judgment is equivalent to
16.1. आगे देखिए 14.2
14.2 is equivalent to 16.2 minutes.
correct. 16.2 14.3
14.3 is 16.3.
नहीं.
In which the trial court has referred to its own paragraph 10 that has come also in the appellate court because copy paste.
Because then subsequently 15.1 of appellate court's judgment is equivalent to 17.1 of the trial court.
15.1 is equivalent to
17.1
17.1 of trial court.
and 15.2 is equivalent to 17.2.
17.2 of trial court.
Subsequent thereto also.
Right.
16.1 of the appellate court.
16.1 discussing
16.1
the-
is equivalent to
18.1 below.
18.1 of the trial court.
Yes, please.
discussing DW1.
Or same copy paste.
DW1. Then 16.2
Subsequent
will not
thereto.
Just
affect
साथ साथ लगते हैं.
Subsequent thereto 16.2 of the appellate court. Paragraph 16.2 of the appellate court.
एक सेकंड थोड़ा सा गलती हो गया. 16.1 of appellate court is equivalent to 18.1
One.
of trial court. 16.2 of appellate court is equivalent to 18.2 of trial court.
2 माने 1 1.
हाँ ठीक है. उसके बाद
Then 16.3.
16.3.
16.3 of
One, one,
appellate
one.
court is equivalent to
18.111.
18.3 of appellate of trial court. Correct?
Below. In these three paragraphs,
Subsequent
DW1,
thereto also.
DW2,
सर प्लीज साथ में मत. आपका तो जो है ना आपने ड्राफ्टिंग में भी एरर कर दिया है. आपने ठीक से पैराग्राफ भी नहीं लिखा जो कॉपी पेस्ट. आपने कहाँ एग्जॉस्टिव लिखा है. 30 के बाद नहीं लिखा. फाइंडिंग पोर्शन का कॉपी पेस्ट नहीं. और बताइए.
Plus para 17 of the appellate court's judgment is equivalent to para 19 of the trial court judgment.
And 19 of the trial court.
17 of trial court is equivalent to 19 of
Okay. Para 17 of trial court.
because 17 of appellate court
17 of appellate court is equivalent to
19 of trial court.
19 of trial. काफी है. और भी होगा.
20 पूरा ही है.
पूरा ही है ना.
Only some of the words are different. जैसे in
क्योंकि
paragraph
एपिलेंट है तो प्लेंटिव डिफेंडेंट बस उतना ही. पर ऑर्नामेंटल चेंजेस किया है. बाकी द एंटायर जजमेंट इज प्राइमरीली.
no judicial mind has been applied.
It reflects that there is no application of judicial mind, much less independent application of judicial mind. देखिए. वो कहाँ है? हमारी लॉ रिसर्चर किसको बुलाई. Essay number 146 of 2022. The learned counsel for the parties are present. This appeal was admitted by order dated 8/4/2025, which is quoted as appeal. The learned counsel for the appellant has submitted that the trial court judgment, the appellate court judgment is almost verbatim copy paste of the trial court judgment, particularly with regard to the findings recorded therein. Except ornamental changes. The learned counsel has submitted that even while discussing the evidences and findings recorded, the judgment appears to be copy-paste, which reflects that no judicial mind has been applied by the learned first appellate court, and whatever has been recorded by the learned trial court with regard to appreciation of evidences and materials on record has been reproduced and repeated by the learned first appellate court. He has also submitted that even the language reflects that it is one and the same. The learned counsel has submitted that even in case of concurrent findings, the first appellate court is required to apply independent mind to the materials on record, and upon appreciation of evidence, the first appellate court can certainly come to the same finding. The first appellate court is thereafter also required to discuss the findings of the learned trial court and apply its judicial mind to the findings recorded by the learned. The learned counsel submits that the first appellate court has not acted in terms of the mandate of Order 41 Rule 31 of Code of Civil Procedure. He has referred to the various paragraphs and has also read the paragraphs of the trial court and appellate court side by side. Though there is difference in paragraph numbering, but he has demonstrated that the learned first appellate court has substantially copied the judgment of the learned trial. The learned counsel has submitted that the first appellate court has recorded the submissions of the appellant in paragraph
Paragraph 7,
page number concerned.
page number 15 of the judgment.
Paragraph 7 as at internal page 15 of the judgment, but there is no consideration of the arguments advanced on behalf of the appellant. The learned counsel submits that the matter be remanded back to the first appellate court for fresh consideration in evidence. The learned counsel for the respondent has referred to the judgment passed by the Honorable Supreme Court dated 16th of April 2025, reported in 2025 live law within bracket SC 458, to submit that the judgment of first appellate court is not fit for interference merely on the ground that there are certain technical flaws in as much as there is no specific point of determination etc. But what is required to be seen is whether there has been a substantial evidence. However, during the course of hearing, the learned counsel has also been a party at the time of comparison of the various paragraphs which has been pointed out during the course of hearing, while comparing the judgment of the learned trial court and the learned first appellate court. And it is not in dispute that substantially the learned appellate court has copy-pasted the discussions and findings of the learned trial court, and the arguments raised by the appellant does not find specific consideration at any place in the judgment.
And the points of determination which they have raised in the substantial.
Although no point of determination has been framed, but the learned appellate court has discussed all the issues in the same manner as has been done by the learned trial court, and in the same language and in the same tone and tone. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and upon bare perusal of the judgment passed by the learned trial court and the learned first appellate court, it is apparent that the following paragraphs are practically copy-paste of the judgment of learned trial court. The comparative chart is as under. This court, upon perusal of the judgment, this court finds that the learned trial court has not at all applied its independent mind to the materials on record. Sorry? Learned first appellate court has not at all applied its independent mind to the materials on record. And there appears to be non-application of judicial mind to the facts and circumstances of the case. And even the arguments of the appellant, though recorded, does not appear to have been considered by the court. This court is conscious of the fact that although the judgment passed by the Honorable Supreme Court as relied upon by the respondent, there has to be a substantial compliance of Order 41/31 of CPC. And non-compliance of the same by itself may not vitiate the judgment. However, keeping the aforesaid principle of law in mind, this court is of the view that there has been no substantial compliance of Order 41, Rule 31 of CPC, inasmuch as the appellate court has not applied its independent judicial mind to the materials available on record and has been swayed away and almost repeated the findings of the learned trial court in the same manner and in the same language. And this is the situation not only in the matter of recording the finding, but also in the matter of consideration of the materials. In such circumstances, this court is of the view that the substantial question of law is fit to be answered in favor of the appellant, and is accordingly answered as such, and it is held that the learned the impugn judgment passed by the learned first appellate court is fit to be set aside on account of not following the mandate of Order 41 Rule 31 of CPC. Consequently, the matter is remitted back to the learned first appellate court for fresh consideration. Since the parties are present before this court, they are directed to appear before the learned first appellate court on such and such date. I will add one or two judgments to this. It will be slightly different language. It's a remand, and this comparative chart जो है, who has come? Yes, you are here. There are two judgments: first appellate court and second appellate court. Trial court and first appellate court. Right? We have enumerated the paragraphs where it is almost copy paste. 99% copy paste. वो comparative chart आपको बनाया है हम लोगों ने. इनके मेमो ऑफ अपील में भी है, ठीक है, उसको चेक करना है, ठीक है, कॉपी पेस्ट है तो यू नीड टू चेक इट वंस. वी हैव चेक्ड इट बट द ऑर्डर शुड बी वेरी वेरी, ये दे हैव सेड सो इन इंटरनल पेज 4 चार्ट में भी है. I have mentioned it like this. This is appellate court, this is trial court. ये चार्ट बना के उनको हैंड ओवर कर आपको दे देंगे, आप भी चेक करेंगे, एकदम दिख ही रहा है. देयर इज नो प्रॉब्लम. दिस अपील इज अकॉर्डिंगली अलाउड इन द एफोर्सेड टर्म्स. 1-1.5 महीना के बाद का टाइम दे देंगे. कोई टाइम फ्रेम कब का सूट है?
The suit is of
पार्टीज टू कोऑपरेट expeditious disposal का observation.
It is 2014.
2014 का सूट.
Enlightenment.
We are also enlightened. This is happening in Jharkhand.
कई चीज तो आप भी निकाल के उसमें
लेकिन सबसे इंटरेस्टिंग था वो हिंदी का इंग्लिश ट्रांसलेशन.
पता नहीं पढ़ते पढ़ते कुछ लगने लगा कि कुछ
सेम चीज पढ़ रहे.
हाँ, तब हम लगे उसको चार्ट बनाने. बहुत डिफिकल्ट है कंसीव. एक लॉयर का बड़ा गजब का टास्क है.
क्रिमिनल में भी देखे हैं, रिवीजन में देखे हैं, कॉन्करेंट फाइंडिंग रिवीजन में भी देखे हैं कॉपी पेस्ट, है ना? हाँ, कॉपी पेस्ट देखे. और एक चीज और देखे हैं, जिस चीज को मीट नहीं कर पाते हैं उसको ओमिट कर देते हैं लिखने से. इट इज नॉट रिटन एनीवेयर,
is not discussed.
नॉट एट ऑल.
Item 5, first appellate 207 of 2023.
यस, बताइए क्या तकलीफ है आपके क्लाइंट को?
But this is the first appeal, but the suit was filed with a not very limited prayer for cancellation of 2 gift deeds.
Yes.
which
Are you
were-
there for the respondent? Yes, please.
Yes. Suit was filed for cancellation of 2 gift deeds on the ground of non-fulfillment of the conditions mentioned in the gift deed. 2 gift deeds were registered gift deeds. The lordship में
थोड़ा सा इस पर ना लॉ बताइए.
हाँ,
गिफ्ट का कैंसिलेशन या गिफ्ट का कंप्लीशन, इस पर थोड़ा सा लॉ बताइए.
Good.
Which all sections are involved?
section 126,
Section
126 of the
126
Transfer of Property Act.
of TP Act.
Yes.
And
That is all, but that is all.
that is
Yes.
all. TP Act कीजिए. What are the basic ingredients of gift?
But so far as gift is concerned, here there is no denial that gift was given. It is a registered gift. Now it is only the point involved here is that for non-fulfillment of the condition mentioned in the gift deed, whether the gift can be revoked or not. So kindly take note section 126.
The only point for determination. Please formulate it written.
Yes.
Bolliye?
But the only point for determination is that for non-fulfillment of the condition mentioned in the gift deed, whether the gift can be revoked or not.
आपने नोट कर लिया? Whether for non-fulfillment of the conditions of the gift deed, whether the gift can be revoked.
Revoked or not. Yes.
It means that it is an admitted fact there was non-fulfillment of condition.
But it is an admitted fact in the present case that there was non-fulfillment because the condition in the gift deed was that we are giving the land for construction of a college, and that college was till date has not been constructed, although the gift deed is of the year 2002. So that condition has never been fulfilled.
Any time frame given for
So there was no time frame given.
A gift is of 2002.
2002. There are
When
two
was
gift-
the suit filed?
Yes, there are two gift deed notes. One is 17/5/2002.
17/5/2000.
That is Exhibit 2B.
Exhibit 2B.
Yes.
Capital B?
Yes. And 22/2/2002, Exhibit 2A.
Exhibit 2?
2A notes.
The executor of the gift is alive?
But the
Who
one
has,
of the
who has
executor,
filed the evocation?
yes, one of the executor is alive.
Executor is in
The
both the
plaintiff.
deeds are the same?
So,
Executor in both the gift deeds are the same?
no, but one is the father and one is the son.
Okay. 17/5/2002 is by whom?
Yes.
Give the name.
Yes. 17/5/2002 is by the father Harbansh Singh, Sardar Harbansh Singh.
Sardar
Harbansh Singh.
Singh.
Yes.
It is in favor of?
It is in favor of DAV, the defendant or DAV college.
Favor of DAV. You are the?
But I am Sadbir Singh, the son of Sardar Harbansh.
Just a moment. 17/5 is Sardar Harbansh Singh
Yes.
and 22/2/2002 is?
This is not Sardar Sadbir Singh, the plaintiff himself.
So he is representing Sardar Harbansh Singh also? He is
Yes.
the sole legal here?
So he is one of the legal heirs. In a family partition, by virtue of will, that property was also given to him. So there is no dispute so far as title is concerned. Because
No. Is there any dispute regarding party position?
no, there is no dispute.
No
There
non-joint.
is no written statement. There is no written statement, therefore no issue framed. There is no cross examination. They did not appear also.
No WS. No cross.
No cross. Because they never appeared. No one appeared. Because all throughout, we are.
Let me just
Yes.
crystallize this. The FA number 207 of 2023, the learned counsel for the appellant, who was the plaintiff before the learned trial court, has submitted that the only point for determination in the present case is as follows: for non-fulfillment of condition of registered gift deeds, of two registered gift deeds, whether the gift could be cancelled. He submits that two gifts are involved in the present case. One is dated 17/5/2002 within bracket Exhibit 2B, executed by Sardar Harbans Singh in favor of the sole defendant.
So, yes. There are two
Like,
defendants. Not
in
two
favor
defendants.
of
One is DAV
defendants who are president and director of DAV College Managing Committee, Chitragut Road, New Delhi, respectively. The other is the gift deed dated 22/2/2002, which was executed by Sardar Sadhvir Singh in their favor, who is the plaintiff in the case. Sardar Harbans Singh has already expired. He has submitted that no written statement was filed and there was no cross-examination of the witnesses, and practically the defendants did not participate in the suit at all.
But since it is the first appeal, if you want to kindly take the plaint, let
Yes,
us
I
see
will.
the plaint.
Can you hear this?
Yes. Yeah, please. The name and address of the parties to the suit have been correctly mentioned in the post title of the plaint, and the address given in the post title of the plaint are registered address for effective service of notice, and the process and this declaration is being made in terms of provisions contained in Order 6 Rule 14A of the CPC. That the suit relates to land measuring 1.13 acres.
कब आपकी जरूरत नहीं होगी? नेक्स्ट कब कौन आएगा और कब? कितने बजे? 12?
12:20.
हाँ बस अब आप जाइए.
That the suit relates to the land measuring.
इन लोगों का टाइपिंग का काम पेंडिंग
हाँ.
आता है. They'll do that.
That the suit
आप जाइए, जरूरत नहीं.
relates to the land measuring 1.13 acres of plot number 139 and also measuring an area of 8.04 acres of plot number 582, 0.82 acres of so plot number of Street Dalton, Palamu, which are situated within the jurisdiction of the learned court at the same is herein are after described in schedule of the plaint in after referred to as the suit land of the property. At Babu Harbans Singh, now deceased, have acquired 5.33 acres of lot in lot number 139 and the khata number 128, village Chianki of PS Daltonganj district Palamu, to registered sale deed in the name of his minor elder son Rudeep Singh, now deceased. The aforesaid Harbans Singh, out of his sweet will and sound mind, executed a will for 5.33 acres in plot number 139 under khata number 128 of village so and so, beside property in favor of his son Rudeep Singh and Sarbir Singh on 10th March 1999, by which 2/3 share shall be of the plaintiff. That Babu Harbans Singh, now deceased, has also acquired land measuring 8.05 acres in plot number so and so under khata number itna to registered sale deed number 5943 dated 19/9/1964, and the aforesaid Harbans Singh, out of his sweet will and sound mind, executed will in so and so in favor of Sarbir Singh for aforesaid 10.86 acres. That the aforesaid Harbans Singh executed and registered general power of attorney in favor of Sarbir Singh, the plaintiff, authorizing him to transfer or manage the property of plot number so and so aforesaid on 28 December 1998. That the suit land is situated near Daltonganj town and located near education area. Therefore, DAV management committee was desirous to open and start engineering college. As such, the committee was in search of proper land for the same, and in course of attempts, the plaintiff and his father came to in contract with management committee of DAV. That after long discussion, the plaintiff and Harbans Singh came in conclusion that they will provide the land for opening engineering college in terms of conditions for which the committee also agreed. That in pursuance of the agreed terms and conditions, deed of gift for land measuring 8.04 acres of plot number was executed on 22/2/2002 by deed number 1659 in favor of managing committee DAV New Delhi by the plaintiff. Now, similarly, under the agreement and terms and conditions, Sardar Harbans Singh executed a registered deed of gift for land measuring itna acres in plot number itna on 17/5/2002 in favor of DAV managing committee. That in both the deed of gift, that is 22/2/2002 and 17/5/2002 referred above, the condition number 3 was that in the event the land under both the gift deeds referred above are not used for the purpose of intending college for which the same is given, or in alternative the college is abolished or shifted elsewhere, the land with the buildings and structures thereon shall revert to in the donor or his heir, that is plaintiff, and if the deed of gift was never executed. That as if this gift deed was never executed, that in spite of the aforesaid execution and registration of the gift deed, the gifted land under the suit remained in possession of the plaintiff and never used for construction of building for engineering college by these defendants, and the suit land still remained vacant and in possession of the plaintiff since 2002, that the defendant failed to make construction of the building for engineering college over the suit land, and the defendant has started proposed engineering college on another place, and therefore as per terms and conditions the plaintiff has right to get declaration that the gift deed number so and so and it now of the year 2002 are revoked. That it is relevant to state that Harban Singh died in the year 2003, leaving behind his two sons, Gurdeep Singh and the plaintiff, who were the beneficiaries under the bill referred above. That to avoid the litigation and to live peacefully, both brothers Gurdeep Singh and Satbir Singh entered in family arrangement and executed a document on 11th August 2021 by which the land measuring 1.13 acres of plot number Itna donated to engineering college shall be of the plaintiff in case returned by the AV college. Hence the plaintiff is entitled for declaration that the defendants are not interested to construct the building engineering college and for considerable period has expired, and thus the plaintiff has reasonable faith that the suit land would
will
not.
और फैमिली अरेंजमेंट का क्या रोल है?
नहीं, will और family arrangement का नोट बता रहे क्योंकि father execute किए थे एक
बिल का क्या रेलेवेंस?
उससे कोई रेलेवेंस नहीं, कोई
There
रेलेवेंस
is a registered gift.
एकदम, it is a registered gift, there is no dispute so far as title is concerned. So नोट bill हुआ उसमें दोनों भाई amicable partition करके उसका कोई रेलेवेंस नहीं.
Irrelevant.
For deciding
वैसे
this,
भी उसका प्रोबेट तो हुआ ही नहीं है, वैसे भी irrelevant है.
वैसे भी relevant है on basis of inheritance also.
Inheritance also.
Inheritance also I have a right. So therefore
ये जो नया कॉलेज खुला है ये कहाँ, इसका कोई डिस्क्रिप्शन नहीं है.
not नया कॉलेज जो खुला उसका डिस्क्रिप्शन नहीं है इसमें.
क्यों?
ना ही हम कोई डॉक्यूमेंट्री एविडेंस रीड कर पाए at the trial.
Your entire case is that they have opened the engineering college
somewhere else and they have not constructed the college on the gifted land.
That's right.
So these are 2 points.
So ये second चीज को आप कैसे प्रूव करेंगे?
But second चीज को I have led oral evidence to show.
कहाँ पे बना दिए?
हाँ, हम दूसरा जगह का नाम भी दिए oral evidence में.
कुछ तो आपके प्लेंट में कहीं नहीं है भाई.
प्लेट में नहीं है, मतलब प्लेट में खाली है क्या दूसरा जगह बना.
दूसरा जगह तो डीएवी है ना, डीएवी तो पूरा दुनिया में बना रहा है.
मतलब दूसरा जगह बनाए है, यहाँ पे नहीं बनाया है, and मेरा land is still vacant and no construction have been made on that. That is 2 points on which plots.
बनवा दे इनका इंजीनियरिंग.
और ये बनाने ही नहीं चाह रहे because
नहीं मीडिएशन में भेज देते हैं. नहीं
आप-
समझ आता है. मीडिएशन में देखिए आपके गिफ्टेड में कोई टाइमलाइन नहीं, ठीक है. आप बोल रहे हैं दूसरी जगह बनाए, दूसरी जगह बनाया का कुछ भी बेसिक फैक्ट भी आपके प्लेट में. यू शुड बी हैप्पी बन जाए तो.
but it was
बताए भेज दे मीडिएशन.
So ready. In fact, my client
But
did
इनका
not file WS, did not contest, because we are still open to considering.
no
it.
mediation notes to the extent कि whether they want to construct or not.
They will
Correct,
construct.
हम उसी पे
हाँ.
आपको क्या लग रहा है? जब तक कंस्ट्रक्शन नहीं हो जाएगा ये पेंडिंग ही रहेगा यार. ऐसा नहीं.
And it क्यों? क्योंकि there were certain conditions also.
See,
Yes,
condition did not have a timeline,
yes, definitely.
right? आपने कॉज ऑफ एक्शन बनाया कि इन्होंने दूसरी जगह बनाया, ठीक है. दूसरी जगह बनाने का कोई फाउंडेशनल डिटेल आपके इसमें नहीं है.
प्लेट में नहीं है.
प्लेट में तो होना चाहिए ना.
But
यू
plate
आर
में खाली-
सीकिंग एन एक्स पार्टी डिग्री.
But ex party तो हमको पता नहीं था जब
तो
हम प्लेट
पता नहीं था ना, तो आपका प्लेट में नहीं है.
हाँ, लेकिन जब
कब बनाया, कहाँ बनाया, नॉट ओनली बनाया, कब बनाया इज इक्वली इम्पोर्टेंट. गिफ्ट के बाद बनाया, गिफ्ट के पहले बनाया, किस जगह पे बनाया. बिकॉज
on that note plaint is silent.
प्लेट इज
only
साइलेंट,
says-
एविडेंस इज आल्सो
Plaint
साइलेंट.
only says कि दूसरा जगह बना.
ये थोड़ा
हाँ, अगर ये पॉइंट
आपके
रेफर
पार्टी
कर
है.
party name notes, लेकिन I have instructions if your lordship wants to refer this for mediation on this point that whether they want to construct or not.
कुछ point ही नहीं है इसमें।
Not mediate तो यही होगा ना कि हमको आज के नहीं, अब तो ये जिंदगी भर में बनाएंगे
अभी
नहीं on the
उसके लिए
ground.
मीडिएशन में क्यों भेजना है? यही पे हम आपको इंसर्ट कर
हाँ, इनसे इंस्ट्रक्शन ले लिया जाए कि बनाना चाहते हैं कि नहीं बनाना चाहते, अगर बनाएंगे तो कितना टाइम लगेगा?
बनाना चाहते
हम इंस्ट्रक्शन दें।
लेके आइए अंदर बन जाए।
हाँ.
ठीक है, कैसा इंजीनियरिंग कॉलेज बनाएंगे बताइए।
Has to be it was only mentioned engineering.
हाँ ठीक है,
Intended
बढ़िया
for-
बनाएंगे ना। डीएवी चेंज
DAV engineering.
इंस्ट्रक्शन लेके आइए, इसको हम लोग लिटिगेट नहीं करने देंगे। अगला मर गया, उसकी इच्छा को पूरा करें। चलिए इंस्ट्रक्शन लेके आइए।
कल पे
कल पे रख देते हैं।
because I am not getting through another council. I will have to go through. On
कितना
Monday,
जमीन है?
So जमीन है total
Monday
10 acres and something.
अब तो क्या है ना कि किसी भी इंस्टीट्यूशन के लिए इतना हाईटेक हो गया है सब चीज़ कि बहुत ज़्यादा लैंड की ज़रूरत नहीं है। मल्टी स्टोरी बिल्डिंग में भी बड़े बड़े इंस्टीट्यूट चल सकते हैं, राइट? सो लैंड से बहुत ज़्यादा मतलब नहीं है। वी आर मोर इंटरेस्टेड इन क्वालिटी।
we have given some reason. They have filed an IA for reducing additional evidence. To that we had filed a counter affidavit in which we have stated that from some portion of that land a road has passed and therefore there were operational difficulties also. When they gave that IA that we still want to give a fresh evidence regarding the college being set up elsewhere.
ठीक है,
So in
रोड है तो
response-
है, that will be taken care of. It will be just a road passing through.
गैर मजूबा लैंड है उसमें इसीलिए।
देखिए, अगर प्राइवेट लैंड में भी रोड है ना तो उसको आप खत्म नहीं कर सकते। एग्जिस्टिंग रोड है तो आप उसको खत्म नहीं कर सकते।
नहीं, बाद में NH चला गया है। That is why
तो
the
एक्वायर
college
हुआ
was-
होगा ना, एनएच तो बिना एक्विजिशन के नहीं होता।
नहीं, that is what they will have to clarify. शायद उसको गैर मजूबा ट्रीट करके उसमें से रोड ले लिया गया without compensation.
वो तो यू विल टेक केयर
Road-
ऑफ, क्योंकि
They have
गिफ्ट नाउ देयर इज अ गिफ्ट इन योर फेवर, राइट? अब इट इज फॉर यू टू टेक केयर ऑफ द प्रॉपर्टी। अब आप उसका क्या करेंगे, नहीं करेंगे, कैसे करेंगे, दैट इज फॉर यू टू फाइंड आउट।
My instruction is that they're interested. Appellant is also running another school. He's also part of the DAV managing committee in that other.
इन अनदर एरिया। तो हम मेरे पास बहुत सारा जमीन हम सब जगह गिफ्ट किए, जहाँ ये बना दिए। नोट कंडीशन बहुत सारा है
आप
कि ये
बहुत-
मेरे नाम से बनाएंगे, हमको वहाँ पे मैनेजिंग पोजीशन देंगे।
आपके चलते ही झारखंड का एजुकेशन टिकेगा।
बट हम तो यही चाह रहे कि अगर बनाना है तो कम से कम 2002 से गिफ्ट दिया हुआ है, 20 साल।
बनेगा, आप चिंता
अगर
मत करिए, आप इंस्ट्रक्शन लेके
हाँ,
कब मंडे को रख दें।
Monday.
Then you will have to, then once you, both of you seek instruction, and then you have to file a joint compromise petition over here. ठीक है, उसका कोई टाइमलाइन भी आपको देना पड़ेगा, करेक्ट?
but anyways I have to only agree because
हाँ.
they have to say कि we will make construction and within this much time
You have to only agree.
and obey by the terms of the gift. That's all. I have to agree.
तो joint compromise तो फाइल करना
नहीं,
पड़ेगा
they
ना,
have to-
फर्स्ट अपील
They
है
have to
ना।
make a proposal first, no?
Yes, and
They have
you
to
will
make a proposal first and then I have to accept and then only you can file a joint proposal. So if they give me a proposal on Friday, on Monday we can file it.
First appeal number 207 of 2023. Learned counsel for the parties are present. अच्छा, वो तो आपको आप ही लिख रहे थे, अब गए नहीं?
नहीं गया था फिर आगे फोन किया।
अच्छा ठीक है, तो बुलाए होंगे। After having heard the matter for some time, counsel for the respondents has submitted that there was no timeline prescribed in the gift deed for construction of the engineering college. He has also submitted that he has some instruction that the respondents are still willing to construct the engineering building, but he has to seek concrete instructions on this aspect of the matter, and also the timeline within which the respondents will be in a position to construct the engineering college, and for that purpose he prays that the matter be posted on Monday. The learned counsel for the appellant has submitted that in case the respondents come up with a proposal for construction of engineering college, as per his understanding and discussions with the appellant, they were also throughout interested in construction of the engineering college over the gifted property. He submits that it is all likely that the appellant would accept the proposal for construction of engineering college, which may come up at the instance of the respondents. And if an agreement is, in principle, is arrived at between the parties, then a joint compromise petition can be made. Correct? Both the parties are directed to seek instructions. Post this case on Monday. वो सब लिखेंगे ऊपर. इस बार इंजीनियरिंग कॉलेज में एक्सक्लूसिवली कंप्यूटर्स करते हैं, AI वाला.
अब तो DAV के पास है.
वो लोग अब नहीं, अब तो क्या है ना कि इंजीनियरिंग कॉलेज एज अ कॉलेज लगता है कि बहुत ज़्यादा मल्टीपल डिसिप्लिन एक साथ है. अब तो वो समय आ गया है व्हेन यू विल हैव सेपरेट इंजीनियरिंग कॉलेजेस फॉर मे बी कंप्यूटर्स, मे बी AI.
Now software engineering or computer
कोई
engineering is
कॉन्सेप्ट
not a
नहीं है ना,
branch.
इज नॉट अ
AI and machine learning is a branch.
हाँ.
Automotive engineering is another branch.
Yes. तो
Specific.
अब ब्रांच वाइज भी इंजीनियरिंग कॉलेजेस सेटअप हो सकते हैं. जैसे कि अब नाउ देयर इज नो कॉन्सेप्ट ऑफ an advocate knowing every law. अब
Yes.
कहाँ कॉन्सेप्ट खत्म हो गया ना.
But say in future, not say there should be like
अब
this.
थोड़े दिन में सेग्रीगेशन जजेस का भी होगा. There is no such concept as of now. I think ये सब अब blurred होते जा रहा है. धीरे धीरे लोग अपना अपना फील्ड मार्क करते हैं. कितने बजे? 10:30 बजे आप देंगे इंस्ट्रक्शन?
तो डीएम को खाली कल बता दे तो हम भी अपने क्लाइंट को अभी छुट्टी है तो बुला के पूछ लेंगे. प्रपोजल उनको दे देंगे, व्हाट्सएप पे भी कर दे क्या ये आया है इंस्ट्रक्शन, तो हम फिर बात करके अगर होगा तो मंडे फाइल ही कर देंगे.
ठीक है.
तो मंडे 10:30 रहे, हम लोग इन्फॉर्म कर देंगे कोर्ट को. अगर एग्री हो गया तो हम लोग फाइल करके उसी दिन हो जाए.
ठीक, 10:30 at 10:30.
For admission, item 22, content is 402 of 2025.
Content civil 402 of 2025. Nobody appears on behalf of the parties. Post on 8th of August.
For hearing under order 41 rule number title 23, second appeal 378 of 2019.
This is defendant second appeal against judgment of affirmance.
Judgment of affirmance.
Suit has been filed by the plaintiff for ejectment of the defendant from this Schedule B property also. If an lawsuit may permit, I may place the specific relief has been claimed by the plaintiff in the plaint also.
What was the claim for? Where is the trial court
23.
decree?
Well, title suit number 23 of 2006 your last.
What is this interlocutory application for interim relief?
For interim.
Where is the trial court decree? Let us see the relief rate for in this suit. I think your decree you have not filed. Is it
Trial court
necessary?
degree, appellate court degree has been filed.
Yes, but
For-
trial court decree has not been.
Not been filed.
Anyways, what was the suit for?
Suit has been filed by the plaintiff for escheatment of the defendant from the Schedule B property. The specific relief has been claimed by the plaintiff. I may read from the plaintiff also.
Yes. Not from the plaintiff, read from the judgment.
Not.
There are concurrent findings, so you will find everything in the judgment. Internal page 2 of the trial court judgment gives the relief.
Not. The suit has been brought by the plaintiff for relief A, passing a decree in their favor and against the defendant for evicting the defendant from the premises mentioned in Schedule B of the plaint and directing the defendant to hand over the vacant position of the Schedule B premises of the plaint to them. Relief B, passing a decree for permanent injunction restraining the defendant, their men, agents and employee and servant, including any obstruction, disturbance in enjoyment of the peaceful enjoyment and possession of Schedule B premises of the plaint by them. C, passing a decree for cost of suit and other relief to which the plaintiff are entitled to get the equity. No relief has been claimed for declaration of right title interest and confirmation for declaration of right title interest of the plaintiff over the suit property also. Plaintiff has claimed their right on the basis of deed executed by the Munsif Hazaribagh in specific performance suit lawsuit. They are claiming on the basis of an agreement executed by Dijendra Prasad in the year 1945, against which suit has been filed for a specific performance. That suit has been dismissed, against which appeal has been preferred. That appeal has been dismissed.
No. By agreement of sale was followed by a registered sale deed
Lordship.
dated 16 month
For
57.
the performance of that agreement for sale, suit has been filed for a specific
Maybe.
Lordship.
But there is a
That has
registered
been
deed
followed
also.
by, that has been followed by the deed executed by the learned
That's right.
Lordship.
So,
May kindly see the issue framed by the learned trial court. Issue is page number 22, Your Lordship. Internal page number 22 of the learned trial court.
yes. Which issue are you concerned with?
Issue number 6, Your Lordship. At page number 25, the learned trial court has contended that the issue number 6, 7 and 8 is a core issue. Main issues they have considered that. Issue number 6, Your Lordship. Whether have the plaintiff got valid right, title, interest and possession over the suit land, even though no relief has been claimed by the plaintiff for declaration of their right, title, interest over the suit property.
Need not be. You see, it is the entire plaint which has to be seen.
Lordship.
Entire plaint as a whole. Suppose a suit is for eviction. Plaintiff says that there is no dispute about my title. So therefore, why should I apply for?
As per the order 7 rule 7, Your Lordship, specific prayer has to be made, the specific
Not
relief has to be
necessarily.
claimed, Your Lordship.
Not necessarily. When there is no dispute regarding his title.
And so far as the claim of the plaintiff is that the defendant is in permissive possession over the suit property and no oral evidence as well as documentary evidence has been produced by the plaintiff to prove that the defendants are in permissive possession of the father of the plaintiff. No finding has been made with regard to that.
You are the defendant.
I am the defendant.
What is your case?
My case is from since 1905, one Raklal Vardhan has got possession over the suit property and making construction over that, and since then he has in possession over the property till
Did you claim adverse possession?
not
Did you claim?
not specific adverse possession, Your Lordship, but I am in the permissive possession of the one Kartik Chandra Day.
Who is Kartik Chandra?
Kartik Chandra Day is my father-in-law.
And who is Raghunandan Day?
Raghunandan Day is the purchaser of that property. The agreement holder subsequently deed had been executed by the learned Munsif Hajari Bhai.
Executed by Kartik Chandra?
No, Your Lordship.
कुछ नहीं है।
I am in the permissive possession of Kartik Chandra, Your Lordship. Since 1905, before the conditional survey records of right, one Raklal Vardhan was in possession, and even the Bakabze column of the Khadian Act has been mentioned that the Raklal Vardhan is in the possession of that property.
देखिए सेकेंड अपील में इस तरह से नहीं बहस करिए. You read the findings. पैरा नंबर 13 पढ़िए आप ट्रायल को.
Issue number 6, 7 and 8.
हाँ, जहाँ पे आपको perversity दिखे पॉइंट आउट करेंगे.
Whether have the plaintiff have got valid.
Right. सीधे नीचे आइए. Bottom.
It is pertinent to mention here that these issues are related to each other, and as such they are being taken up jointly for the sake of convenience. It is shown in the issue number 6 that is related to right, title, interest and possession over the suit land, but from plain reading of the plaint and written statement, it is clear that the case is not related to possession. Possession over the suit land of the defendant have already been admitted. So far, right, title and interest over the suit land of the plaintiff is concerned, the plaintiff to prove both the claim produced oral as well as documentary evidence by claiming that suit land was purchased land of the predecessor of the plaintiff Raghunandan Day and Kala Chande, measuring an area of 17.5 decimal by agreement of sale dated 4/9/1945 from the Dijan Prasad, which was later on converted into registered sale deed number 368 dated 16/1/1957, executed by the Munsif Hajari Bagh dated 22/12/1956 in execution of degree passed in title appeal number 83 of 1949, by judgment dated 31/5/1956, and as such they remain in continuous, peaceful and undisturbed possession over there. In the meantime, in the year 1970-71, the defendant Nitai As, who was Banoy of Raghunandan Day, requested Raghunandan Day to stay in the house situated in plot number 3573, Khata number 518 Moja, Saram, to whom said Raghunandan Day allowed to occupy, and accordingly he came in permissive possession of the Schedule B of the suit land, and in the meantime defendant number 1 got a basket purchase in his name, which was lastly rejected by the Anshana Adhikari on 27/10/1993 as per order passed in SWJC number 398 of the 98R of the Honorable High Court, Patna, and as per the name of the plaintiff by mutation case number 136 of the 90 dated 10/10/1990 was muted by the Anshana Adhikari Gomia. Whereas the defendant have stated that the suit land was acquired by Dundaram Patwa and Salim Ram Patwa. Dundaram Patwa died leaving behind his two sons, namely Mohan Ram Patwa and Lakhi Ram Patwa, whereas Salim Ram Patwa died leaving behind his two sons, namely Ramdas Patwa and Sitlal Patwa. In the last survey settlement, non-cadastral survey settlement, the suit land was in possession followed in the name of Raklal Vardhan. This is the case of the defendant. And after his death, his widow came into actual possession over the suit land, who gave the land plot number 3573 to Kartik Chandra, and after that Kartik Chandra gave the suit land to Nitai Chandra, defendant number 1. And they have also acquired right and title over the suit property by the adverse possession. In support of the pleading of both the parties, they have reviewed and examined the oral evidence as well as documentary evidence. In witness examined on behalf of the plaintiff have supported the contention of the plaintiff. Similarly, the issues examined on behalf of the defendant have supported the contention of the defendant. But the document filed on behalf of the plaintiff, which were proof and mark exhibit, which is exhibit 1 to 1/8, so that these are rent receipts regarding the suit land and was granted in the name of Satnarayan Day. Exhibit 2 is the advocate notice dated 11/7/2006, which show that the plaintiff sent the said legal notice to the defendant with a prayer to vacate the suit premises. That Exhibit 3 is the judgment of Title Appeal number 82 of 1949, which shows that the disputes regarding suit land were decided by the first additional subordinate judge Hajaribagh on 31st 5/1956, wherein the court was pleased to direct the plaintiff Raghunandan Day. The suit was directed to that suit was directed to deposit rupees 430 within a fortnight from the judgment, and on the event of that, defendant was directed to execute sale deed in favor of said Raghunandan Day. The Exhibit 4 is the sale deed number 368 dated 22/12/1956 in compliance of Exhibit 3, which was executed in the name of Raghunandan Day by the learned Munsif on behalf of the defendant. The
कुछ
exhibit-
नहीं है भाई. There is nothing in the case. All the documents have been considered. During the pendency of the suit, you sold. So list pendants will apply.
That I am not claiming that.
So that's
But my lord, I am
not a
the
case.
Lal Bagan is in possession since 1905,
Maybe.
and they have been continuous in possession.
Maybe.
And
Adverse possession तो आप claim इसलिए नहीं कर सकते क्योंकि you were claiming by virtue of a sale deed. Then how do you claim
I'm
adverse
not claiming
possession?
on the basis of it. But the plaintiff has failed to prove that the
I've heard you
defendant are in
enough.
permissive possession
Not a
over the
case.
suit land.
Not a case. Not a case for it. Second appeal number 378 of 2019. Heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against a judgment and decree dated 5/8/2019, within bracket decree signed on 16/8/2019, bracket close, passed by learned district judge Bokaro, whereby civil appeal number 10 of 2019 has been dismissed, and the judgment and decree dated 20/12/2018, within bracket decree signed on 9/1/2019, passed by learned civil judge within bracket senior division bracket close first Bedmo at Tenughar, entitled suit number 23 of 2006, has been upheld. The suit was decreed by the learned trial court, and the defendant is the appellant before this court against concurrent finding of facts recorded by both the courts. The learned counsel for the appellant has referred to the relief as prayed for by the appellant and as by the plaintiff, and has submitted that the plaintiff never sought any declaration of right title over the suit property. Rather, the plaintiff was filed seeking eviction of the defendant from the Schedule B property by stating that the defendant were in permissive possession of the property. The learned counsel has submitted that the defendant was claiming the property through Kartik Chandra Day. Kartik Chandra Day, and was in possession of the property since long. He submits that in absence of any relief claiming declaration of title over the property, the learned court could not have framed and decided the issue as to whether the plaintiff has got right title, interest and possession over the suit land. The learned counsel has also submitted that the defendants were admittedly in possession as the plaintiff was seeking recovery of possession of the suit property. He has submitted that the issues framed by the learned trial court bearing issue number 6, 7 and 8 were the main issues for consideration. The learned first appellate court has formulated the point for determination in paragraph 8 of the appellate court's judgment, which are as follows. The learned counsel has submitted that the appellate court has also framed an issue as to have framed the point of determination as to whether the plaintiffs have right, title and interest over the suit land. And further, the appellate court has also considered the point of adverse possession. But since no relief was paid with regard to right title of the property, therefore such issue would not have been framed and decided. After hearing the learned counsel appearing on behalf of the parties and going through the judgments passed by both the courts, this court finds that though the plaintiff has not paid for declaration of his right, title and interest over the suit property, but the background of the case was that the plaintiff was claiming the suit property on the basis of registered sale deed dated 16/1/1956, which itself was executed by virtue of judgment passed by virtue of order passed by Munsif Hazaribagh dated 22/12/1956 in execution of decree passed in title appeal number 8349 by judgment dated 31/5/1956. And the plaintiff also claimed that one Baskik Vacha was issued in favor of defendant number 1, which was also subsequently cancelled. Since the defendant was claiming the suit property on the ground that, by asserting that the land was acquired by Dhuruvdam Patwa and Salim Ram Patwa, and in the survey settlement, possession was shown in the name of Rakhal Bardhan, and after his death, his widow came in possession of the suit property, who gave the suit property to Kartik Chandra Dey, and after that, Kartik Chandra Dey gave the suit land to Nitai Chandra Ash, who was the defendant?
Who is the original defendant number?
Who was one of the defendants in the case. The defendant were also claiming the property by virtue of a sale deed executed by who gave the property. They also claimed adverse possession.
That sale deed had been executed by Vijendra Prasad in favor of Kartik Chandra in the year 1940.
It has been pointed out by the learned counsel for the appellant at this stage that who executed the sale deed?
Vijendra Prasad.
One Vijendra Prasad.
Against which a specific performance has been claimed.
had executed the sale deed number
Sale deed, that is exhibit C, your lordship. Sale deed number
5480
dated
dated
20th 9 1948.
29
1948.
1948 in favor of Kartik Chandra.
Kartik.
दुजेन प्रसाद ने the sale of Rakhal Chandra बता रहा है इसमें.
The Rakhal version so already he is claiming on the basis of that was purchased in 1948.
He was claiming the property by virtue of Exhibit C, which is sale deed dated 5480 in favor of Kartik Chandra. बस इतना ही लिखिएगा, वेंडर का नाम लिखिएगा जरूर. After hearing the learned counsel for the appellant and upon going through the improved judgments, this court finds that though the plaintiff did not specifically pray for declaration of his right, title and interest over the suit property, but upon notice to the defendant claimed title over the property, and consequently the parties joined issue in connection with right, title and interest over the suit property, and the appropriate issue was framed. This court is of the considered view that the plaint and the written statement is to be taken as a whole for the purposes of framing issue, merely because no specific relief was prayed for in the suit for declaration of right, title and interest. It cannot be said that no such issue could have been framed. The case of the respective parties by deciding issue number 6, 7 and 8 has been fully discussed based on the materials on record in paragraph 13 of the trial court judgment. The learned trial court has clearly recorded the basis in the case of the findings of the learned trial court is in paragraph 16 and 17 dealing with case of the respective parties, which is quoted as under. During the course of argument, the learned counsel for the appellant has not been able to point out any perversity in the matter of discussion of evidences on record. The learned first appellate court also considered the materials on record and ultimately held that the plaintiffs are the rightful owners of the suit property. The learned first appellate court has discussed the materials and rejected the plea of adverse possession of the defendants by well-reasoned order, and has also considered and also recorded that the plaintiffs are the rightful owners of the suit property. This court finds no illegality or perversity in the impugned judgments passed by both the courts, and accordingly this appeal is hereby dismissed.
Apologize for interrupting you. In senior number 22 relations, I was to appear on behalf of the state, and I was only in court number 14 and couldn't reach on time.
No problem, I have just adjourned it.
My appearance leadership on last occasion,
Appearance नहीं record कर सकते ऐसे बात.
I was on the podium leadership,
No, it doesn't make any difference. You ensure compliance. Compliance has been done.
no, it is coming for the procedure. On last occasion, it was not taken.
Without an, you want to comply or
Yes, leadership. Compliance and affidavit has to be valid.
comply it. Suo motu.
Item 24, second appeal, 1 double.
Sorry? What do you say?
18 February order here also continue for
18th February. So what is it? Where is the additional evidence?
also by file and IA also
Last time आपका additional evidence देखे थे ना हम लोग? 18 फरवरी के बाद भी ये मैटर आया.
yes 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 also it's मई का ऑर्डर है also लास्ट चांस दिया गया था इसमें IA फाइल की also for additional evidence IA number 6998
वो तो आपने यहाँ लास्ट चांस हमने आपको आईए फाइल करने के लिए नहीं दिया था,
Additional
आपने
evidence
फाइल कर दी.
नहीं लॉर्डशिप एडिशनल एविडेंस के लिए लॉर्डशिप अंडर 7 एंड ऑर्डर 41/27 लॉर्डशिप
आपका कहना था कि ट्रायल कोर्ट ने एडिशनल एविडेंस आपने फाइल किया लेकिन उसने अलाउ नहीं किया.
नहीं किया
आपने तो लास्ट मोमेंट में फाइल किया.
लॉर्डशिप वो फाइल कर दिया था लॉर्डशिप तो लास्ट टाइम में बोला गया था लॉर्डशिप कि लास्ट का डेट रखा गया था इस बीच में ही हमको फाइल करने का था हम फाइल कर रहे हैं
आपका ये वर्बल बातों से हम लोग अपने जुडिशियल ऑर्डर को थोड़ी चेंज करेंगे.
लॉर्डशिप आई फाइल आईए लॉर्डशिप प्रेइंग फॉर द for additional evidence lordship kindly before
At this appellate stage.
this lordship it is power of the appellate court.
Substantial question of law बन गया. अभी तो सब्सटेंशियल क्वेश्चन ऑफ लॉ ही नहीं बना है तो क्या हम आपका एडिशनल एविडेंस देंगे. रिव्यू जजमेंट कब का है? एपेलेट कोर्ट.
Appellate court 2022 November 22
आप उनको जजमेंट से दिखाइए दैट बिकॉज ऑफ दैट पर्टिकुलर जजमेंट द ऑर्डर हैज बीन प्लेस्ड.
finally page 20 or also trial court order. It is reflected in the
पेज 20 और
page 20 or my
ट्रायल कोर्ट में तो पेज 7 ही है. 7 पन्ना का जजमेंट है, बस 20 पन्ना कहाँ से लेके आएंगे? पेज 20 of what?
of my appeal here also. Trial court order.
इंटरनल पेज बताइएगा क्योंकि सर्टिफाइड
Page
कॉपी
20
अपने बाद में पाई थी
Page
इंटरनल
20
पेज
Internal page 20 है.
इंटरनल पेज 20 नहीं है ना ट्रायल कोर्ट का 7 पन्ना का जजमेंट है इंटरनल पेज बताइए
Running page 20. Running page 20 also.
आपके पास सर्टिफाइड कॉपी की फोटोकॉपी नहीं है उसमें देखिए पेज नंबर 7
Yes, yes.
मिला
Last.
पढ़िए
May I read ऊपर से second paragraph.
पढ़िए
It has already been decided that suit land is non-transferable land and the mutation order in mutation case number 356/26/27 is without jurisdiction and illegal and also does not create any right title to anyone. Consequently, the possession of the defendants over the suit property cannot be claimed as illegal. It is worthy to mention here that in TL case number 38 of 2008 order dated 28 February 2009 passed by settlement officer, the defendants were evicted from the suit land as per provision of section 20 5 and 42 of SPT Act 1949. These provisions have been explained earlier in the aforesaid issues. This order has been filed on behalf of plaintiff, however not executed, but the order is a public document and can be looked into by the court any time, and it is admissible in evidence because it relates to the land in question. That were the challenge before the learned court of the Commissioner University, which has been finalized during the pendency of the case.
You are the defendant?
Lordship?
You are the defendant?
Yes, yes, I am. That's why I filed an IA for additional responsibility. In my IA lordship, the order of the Honorable Apex Court lordship regarding the additional evidence and matter has been referred for the first appeal court to be protest.
In your this particular order, in the order of eviction, the plaintiff is a party.
Yes, lordship.
Where is that order?
Lordship. In my IA lordship, I have next year lordship order security. In my IA 69980 lordship, Annexure 1 page 13 lordship.
Annexure?
Annexure 1 page 13 lordship. Same plaintiff and same defendants.
He has given a declaration of adverse possession.
Lordship.
Power है कमिश्नर को adverse possession declare करने का.
Lordship, the ancestor of the plaintiff.
No, I want to know. He has given a declaration of adverse possession. He has got the power to declare adverse possession.
Lordship 1936 सही है.
कितना भी length क्यों है?
Lordship.
Does the commissioner has got the power to declare adverse possession?
Lordship.
Just see what kind of order he has passed. Page number 4.
As per order of the Mathura
Commissioner.
Prasad Singh case here also. Mathura Prasad Singh case here also, it has been detailed order here also.
Mathura Prasad Singh.
Singh, yes sir also. Page 16 also. And Gauri Lal Jain case here also.
एडवर्स पोजीशन का डिक्लेरेशन कोई ये कमिश्नर को पावर है क्या करने का? Merely because a person is in possession for 50 years, his adverse possession can be declared.
Lordship, in the year of 1936, prior to the
You forget about
perspective of
1936. Let it be 1436.
prior to the
Adverse possession is a declaration by a competent court of law. How adverse possession will be declared by commissioner? Yes. He has declared adverse possession. I just want to know, is it possible? Can he declare adverse possession? Adverse possession सिर्फ possession होने से adverse possession नहीं होता ना. There are so many ingredients of adverse possession. Yes, it is just. I find that the appellant has perfected right title by way of adverse possession more than 12 years prior to 1949. There is no question of eviction. And there is also a by this order has become final.
फाइनल ऑर्डर
इसको चैलेंज नहीं किया कोई.
नहीं लॉर्ड ऑर्डर है लॉर्डशिप बबरीलाल जैन का भी केस का यही ऑर्डर है लॉर्डशिप. मे आई रीड फॉर मोमेंट योर लॉर्डशिप सम पैरा योर लॉर्डशिप.
देखिए इश्यूज बताइए ट्रायल कोर्ट का. You see, issue number Roman 8 is directly relating to adverse possession. Correct? Issue number Roman 8 is directly related to adverse possession. There is an adjudication on adverse possession. तो उस ऑर्डर का कितना रेलेवेंस है? There is a direct adjudication on adverse possession.
1977 में म्यूटेशन भी हो चुका है.
आप हमको ये जो रोमन 8 का फाइंडिंग है, इस फाइंडिंग को असेल करिए. आपका खाली एक जजमेंट के बेसिस पर सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बनेगा. It is just a passing reference that this has also happened. Have you proved your case of adverse possession before the court?
Yes, your lordship, बबरीलाल जैन का ऑर्डर है लॉर्डशिप. May I read for a moment for few lines?
वो नहीं बोल रहा. Before the court, you have proved your case for adverse possession. कोर्ट में आपने अपना adverse possession का claim prove किया है. Because there is a specific issue on adverse possession.
1977 में लॉर्डशिप इसमें पार्टिसिपेट भी किए हैं. इसमें फादर ऑफ द प्लेंटिफ भी लॉर्डशिप अमलनामा भी है. उसी पर म्यूटेशन है लॉर्डशिप.
तो फाइंडिंग पढ़िए. एडवर्स पोजीशन का फाइंडिंग को परवर्स बताइए. उस जजमेंट के बेसिस पे परवर्स नहीं हो जाएगा. राइट? कमिश्नर के जजमेंट के बेसिस पे परवर्स नहीं होगा. आप हमको इसका फाइंडिंग बताइए. Where is the discussion? पढ़िए. पैरा नंबर 9.
पैरा 9. These issues are identically and correlated and accordingly are hereby decided as hereunder. Before deciding these issues, it is pertinent to mention here the argument of the party. At first, I would like to recite the argument advanced by the Council of Defendants. Learned Council of Defendants totally denied the case of plaintiff. Learned Council submitted that it is purely a matter of building a notice was not given to tenant, and also the suit has not been filed under the provision of building act, and as such not mandatory. Learned Council further submitted that the case of the plaintiff is that mutation order obtained by means of fraud, but the plaintiff has not met the circuit officer as party. Notice under section 80 of CPC has also not been given. For the necessary party of the suit not joined, so the suit is not mandatory and be rejected. I would like to meet with firstly the argument that this suit ought to have been filed under the provision of building act, and in this regard some assertion of the plaintiff in plaint may be recited. Up to para 10 of the plan, the assertion of the plaintiff whether the defendant were tenant for rent of ₹100 per month, but later on the pleading change and plaintiff asserted that they came to know about the mutation order in mutation case number 356/76/77 in favor of defendants, and accordingly they claim for right, title and interest and also for declaration of the order of circle officer as null, void and illegal. So on the basis of aforesaid pleading, I am of the firm view that it is purely a matter of title of plaintiff and have rightly filed this suit as declaratory suit. So arguments advanced by learned counsel of defendants is not tenable. The case of defendants is that they were in possession of the suit land since 1936 on the basis of POPA, but said POPA-nama has not been filed by the defendant and mere assertion is not enough. The defendants claim in para 9 of the page 5 of their written statement that Nalavi Patra was executed dated 2/1/2077 in favor of defendants by Rupan Pandit. That alleged Nalavi Patra is on record as Exhibited D. From the result of this Nalavi Patra, it appears that it is in between Rupan Pandit first party and also Pandit second party, and needless to say, it is again hit by section 20 of SPTF 1949 as transfer of Jamabandi land can be made by any manner as such this document have no legal sanctity. On behalf of defendants, there are 8 witnesses. Some of them are formal in nature and others have supported the possession of defendants over the suit property. However, plaintiffs also admitted possession of defendant, but the question is completely legal and the oral evidence will have the least value. If there is possession for the sake of argument since now, the question is whether that possession is legal or not. So unnecessarily reciting the version of witnesses is not necessary. It has already been decided that the suit is non-transferable land and the mutation order in mutation case number so and so is without jurisdiction and illegal and also does not create any right title to anyone. Consequently, the position of the defendants over the suit property cannot be claimed as illegal. It is worthy to mention here that in clear case number 38/2008 order dated 28/2009 passed by section 1 also the defendants were evicted from the suit land as per provision of section 20/5 and 42 of SPTF. These provisions have been explained earlier in the aforesaid issues. This order has been filed on behalf of the plaintiff, however not executed, but the order is a public document and can be looked into by the court at any time and it is admissible in evidence because it relates to the land in question.
Appellate court?
Appellate. Page 29 or para 9 or page 6.
Yes, please read it.
Therefore, from overall perusal of evidences on record, this court finds and holds that the plaintiff are entitled to eviction of defendants from the suit property mentioned in the civil and further mutation case number so and so dated 23/7/1977 is declared illegal, null and void and not binding on the plaintiff, and the possession of defendants is declared illegal. Further, it is ordered that the suit land and any apportionment thereof or thereto is directed to be physically handed over to the plaintiff or the defendant, since it is admitted by the plaintiffs in their pleading as well as evidences that defendants have constructed their house over the suit land and were in possession of suit land since more than 35 years over the period of time, and that too with the permission of the ascendants of the plaintiffs, and on delivery possession of the suit land the apportionment thereto shall also be delivered therewith, which has been constructed and improved at the cost of defendants. Therefore, equity says all the parties shall pay to the defendants or deposit in court within 4 months the cost of construction of the house of the defendants and other expenses incurred by defendants for improvement of the suit land to the tune of ₹20 lakhs as cost of the retribution and return of benefits under section 65 of Indian Contract Act, and also for rehabilitation of the defendants and also the benefit they have received this suit land in the form of constructed property. Further, the SPT does not in any way bar for the providing aforesaid cost of retribution along with return of benefits etc. Therefore, it is directed all the plaintiffs jointly or severally pay the defendants or deposit in degree court within 4 months a lump sum amount of ₹20 lakhs unless the same said amount is paid or deposited in the degree court by plaintiff. They shall not be entitled to possession.
Second appeal number 199 of 2022. The learned counsel for the appellant has submitted that one of the issues which was framed by the learned trial court was issue number 8 with regard to the point as to whether the defendants have perfected their right title over the suit land and house standing over the same, with essentially related to the claim of adverse possession. He has submitted that the learned trial court has considered the same by holding that the defendant was in illegal possession of the property, and while considering the point, the learned trial court has taken note of one order dated 28/2009 passed in TL case number 38 of 2008 by the settlement officer, by which the defendant was directed to be evicted from the suit property. He submits that, as is apparent from the trial court judgment, the said order was not exhibited and it was considered as a public document. He submits that the said order has been set aside by the commissioner who has declared adverse possession of the defendant. The learned counsel has also submitted that the learned first appellate court has not at all framed any point of determination regarding, they has not at all considered the plea of adverse possession. He submits that he has filed additional evidence before this court through interlocutory application to bring on record the order of the learned commissioner setting aside the order dated 28/2009 passed in TL case number 38 of 2008. He has also submitted that, to the best of his knowledge, the order of the commissioner has attained finality. The learned counsel has submitted that this appeal be admitted for final hearing on the substantial question of law as to whether the learned courts have properly considered the plea of adverse possession of the defendants and he submits that the said plea has neither been properly considered by the learned trial court nor by the learned first appellate. As the basic ingredients of adverse possession have not been properly examined. It was a plaint for eviction on tenancy.
Yes, Your Lordship. Complaint was filed by the plaintiff on the tenancy basis, Your Lordship, without any document and evidences. Your Lordship. The father of the plaintiff has himself executed the deed in 1977, Your Lordship. Just after death of his father, Your Lordship, entire case has been filed.
Considering the aforesaid submission, this appeal will be heard on the following substantial question of law. Whether the learned courts have failed to name whether the improved judgments are fit to be set aside on the ground that the learned courts have failed to appreciate the plea of adverse possession in accordance with law. Issue notice to the respondents for which recusants under ordinary process be filed within a period of 1 week from today. It is made clear that the interlocutory application seeking to adduce additional evidence will be considered after appearance of the respondents. The notice should also accompany a copy of the interlocutory application being IA number 6998 of 2025. Call for the records from the concerned court. Admit तो ये हो गया, कब करेंगे बताइए. Post on 31st of July. Awaiting service to court.
Item 25, second appeal 44 of 2023.
Who is for the appellant? In spite of repeated calls, the counsel for the appellant is absent. The prayer were earlier when the case was taken up on 27/8/2024. The time was allowed by way of last chance. No adjournment notice has been circulated. Accordingly, this second appeal is dismissed for non-prosecution.
Item 26, second appeal 57 of 2023.
लास्ट चांस हो चुका है ना आपका, बिना कॉस्ट के एडजर्न नहीं करेंगे. फीवर हो गया, एडवांस नोटिस भी तो नहीं भेजे ना. हाँ, कल रात को फीवर हुआ. हम लोग तो रात को बहुत फाइल करते हैं. 2 बजे भी मैसेज करेंगे तो मेरे पास पहुंच जाए. नहीं हो सकता. एडजर्नमेंट नहीं देंगे, बाय वे ऑफ लास्ट चांस था, हम आपको एडजर्नमेंट नहीं दे सकते. बहस करिए. आर्ग्यू योर केस. It's all the more reason to dismiss the case. He has been engaged to argue the case, no? Yes. सीनियर को तो बुखार हुआ, फाइल को भी बुखार हो गया क्या? वो भी हॉस्पिटलाइज्ड है? हाँ? सीनियर ने मना किया फाइल पढ़ने के लिए. इस केस को टाइम लेने के लिए आपको तो रात ही को पता चल गया था. अभी 1 बज रहा है, क्या कर रहे हैं आप? तो सुबह से भी 1 बजे तक क्या कर रहे हैं? ऐसे हम एडजर्न नहीं करेंगे, बिल्कुल भी नहीं करेंगे. लास्ट चांस देंगे कॉस्ट के साथ. मीटर उसका बढ़ जाएगा कॉस्ट का. 1 वीक के आपको 10 साल का भी टाइम दे सकते. कॉस्ट उसी अनुसार लगेगा. बताइए. वैसे भी हारा हुआ केस है, आपको क्या ही मतलब. फिर सब्स्टिट्यूशन वगैरह फाइल होते रहेगा. आपका राइट टाइटल इंटरेस्ट पोजीशन एज ए प्लेंटिफ, यू कुड नॉट प्रूव एनीथिंग. You are claiming on the basis of a hukum now. क्या substantial question होगा उसका? बताइए. बताइए. एडजर्न नहीं करेंगे बिना कॉस्ट के, हम एडजर्न कर देंगे. पढ़ लीजिए. सेकेंड हाफ. नेक्स्ट
Serial number 25, ma'am.
Mr. DV Kumar is to argue this.
कोई बात नहीं, कोई नहीं आए,
Therefore, it
हम
was,
डिसमिस कर दिए हैं।
मैं इसको डिसमिस नहीं किया, हम सेकंड हाफ में शुरू करेंगे।
नहीं करेंगे।
इसको कर दिया जाए। सेकंड हाफ में अप्रूव करने के लिए।
सेकंड हाफ में हम दूसरा केस आप लिस्ट में नहीं देखे, अभी आर्ग्यू करिए। यू आर्ग्यू राइट नाउ।
Please don't read my report number 3 में।
रिजेक्टेड। चलिए नेक्स्ट।
इसको
Item 27, second to 60 of 2023.
यस प्लीज।
Your Lordship, he is occupied in adjacent court.
सॉरी,
Yes, he is occupied, he is arguing in adjacent court.
कोई बात नहीं, आप है ना, आप तो अच्छा बहस करते हैं, आपको हम सुने हैं, चलिए बहस करें।
But I have not argued with your Lordship relationship ever.
नहीं ऐसा नहीं, हम आपको बहस करते
It has been around 7-8 months only and I have not argued with your Lordship.
आज का दिन है।
Yes, given this opportunity.
Today
I
is the golden
I have not come with a
opportunity.
brief, sir. I have not come with
You are standing without the brief.
Yes, I am standing
तो
without.
brief लेके
to
दूसरा
be
court
very
में।
honest.
आपके सीनियर ब्रीफ लेके चले
What
जाते
goes,
हैं।
what goes with a newcomer? These places you know. that's
आपको
not
तो
been
सीनियर को
in-
सीधा बोल देना चाहिए कि हम तो कोर्ट में नहीं जाएंगे, हमारे पास ब्रीफ नहीं दीजिएगा।
The seniors go
बोले
to
हैं कि
cherry
नहीं
picking
अभी
only,
तक?
yeah.
ऐसा बोले हैं कि नहीं अभी तक?
नहीं,
कौन है आपके सीनियर?
आयुष है।
एकदम कॉस्ट लगाते हैं, जूनियर को ब्रीफ नहीं देते पढ़ने।
लगा दीजिए रेट्स क्लास। मैंने तो बोला रात में कि भाई पूरी कौन सा फाइल पढ़ना है, ये पढ़ लो, फर्स्ट वीक में लो, तुम तैयार करके लियो। मैंने ले आया। और when I am not given the opportunity, what can I do for the leads?
Not given the opportunity for what?
The file has come.
फाइल अच्छा है, फाइल पढ़ी।
You put it
बताइए
in
क्या?
second half leadership, I will be ready.
नहीं, ऐसा कैसे हो सकता है? मिस्टर आयुष आदित्य आपको ब्रीफ नहीं देते पढ़ने के लिए, ये तो हम मान नहीं सकते। इसी बार में हम लोग बड़े हुए हैं ना, हम लोग को पता है कौन क्या कर सकता है। ये स्टेटमेंट आपका सही नहीं है।
It would sound like bit of exaggeration if I say I am having a voracious reader. I have come after 18 years of job.
So you did. If you are voracious reader, read it.
So for final hearing, let's see. I'm just praying that you allot the time, granting some time. If it wants me to just argue the case, I will be ready. I will be given the sincere effort.
We don't want anybody to argue the case. We want the case should be argued by the person who is appealing. Firstly, it is the litigant's choice who has to argue the case. We are nobody to say as to who is the person who has to argue the case, but whosoever is appearing is expected to argue the case, provided he is under the instructions of the counsel concerned or the litigant. We do not know.
That
what-
way I understand. As a mature person, I do understand. Sometimes the situation goes all against you.
I just want to know why didn't you read the file?
I'm ready to read the.
यहाँ पर पहली बार सेकेंड अपील।
This is the second appeal.
आपको लगता है इतना लग्जरी ऑफ टाइम है हम लोग के पास?
No less.
तो
Since I'm not going ever with the file, first thing मुझे दिक्कत है.
I just want to know why have you not gone through the brief?
So I'm not going to send this full paper. So,
लिखिए essay number 60 of 2023. Learned counsel for the appellant. नाम बताइए।
Manish Kumar.
Manish Kumar seeks adjournment on the ground that the arguing counsel is on legs in another court. Post tomorrow by way of last indulgence.
Item 28, second to 76 of 2023.
This case of respondent number 6.
Respond number 6.
Namely, Champa.
Essay number 76 of 2023. The learned counsel for the appellant submits that the respondent number 6 has expired during the pendency of this case.
Yes.
He seeks adjournment. Post this case on 7th of July under the heading for orders.
Item 29, second appeal 107 of 2023.
essay number 107 of 2023. Nobody appeals on behalf of the appellant. In order to give one more chance to the appellant, the matter is adjourned and is directed to be posted on 19th of June, subject to payment of cost of rupees 5,000 to Advocate Clerks Association detail. The receipt regarding cost should be filed latest by 18th of June 2025, failing which this appeal shall stand dismissed without reference to the bench and will not be listed on 19th of June. Let a copy of this order be forwarded to counsel for the appellant. A soft copy be forwarded to him.
There was one matter, item number 25.
यहाँ पर DFD कर दिए, DFD ने एडजर्न कर दिए, 5,000 रुपये कॉस्ट जमा कर दिए। चलिए नेक्स्ट कॉल करिए। 25 में क्या हो गया?
Item 30.
उधर DFD कर दिए। चलिए।
Item 30, second appeal, Jawad 1 4 of 2023.
सेकेंड हाफ में कर लेंगे।